The Royal Commission is now in session. Please be seated.
Yes, I'll just take the day's appearances.
Yes, if it pleases the Commission, I appear with Mr Freeburn again.
Thank you. And Ms Hogan-Doran.
May it please the Commission, I appear this morning with Mr Bruschino and this afternoon with Ms Vial.
All right, thank you. Yes, Mr Gregory.
Yes, Commissioner, Ms Halbert resumes her evidence from yesterday and is present. I ask that Exhibit 2094 be produced on the screen, please. While that's happening, Ms Halbert, it is the communication from you to various persons in DSS and Ms Go Lightly about the comments on the exposure draft. Sorry, not the exposure draft, the draft executive minute.
Mr Gregory, I think this email's to Melissa Ryan, is it?
Oh, Melissa Ryan, yes. Can I just clarify with you, though, that this reflected, that is, the attachment we'll come to shortly, the state of mind in respect of the DHS proposal at that time?
Correct.
Yes. And if we could then go to attachment 2095. That understanding included in the second dot point on this page in respect of the proposal that in some cases there are fundamental impacts on social security policy and law. You see that?
Yes.
And if we go over to page 0193, you'll see particularly the comments which were inserted in the box below and over to the top of page 0194. These comments include, this was the proposal which reflected a fundamental change to the social security law.
That's right.
If we return then to page 0193, you can see under the heading PAYG cleanup in subparagraph B, the last sentence of the proposal indicates that the customer will have an opportunity to update the information prior to it being applied to their Centrelink record. You can see that?
Yeah.
Perhaps if subparagraph B could be...
Yes.
The ATO information referred to in this paragraph is, of course, the PAYG summary provided by employers to the ATO.
Yes.
And your understanding of the proposal and the context in which the DSS position was arrived at included, one, the concept of a smoothing methodology, and two, the opportunity to update the information by a customer.
That's right.
Prior to the smoothing or averaging
That was our understanding.
or apportionment leading to the calculation of a debt. All right. And although that was the DSS position as at Tuesday, 20 January 2015, and despite some watering down or softening of language later in the week, that position didn't change in any substantive way to your state of mind.
No, and I wouldn't call it softening of language, we're just refining the points that we were making to DHS, trying to get heard, I guess.
And that is, the proposal with those characteristics was one known to DSS at the time that it considered it involved a fundamental change to the law, and that position didn't change that week.
Not to my knowledge, no.
And your final communication to Ms Go Lightly about it was the Friday the 26th.
Yeah. I think it was Friday the 23rd.
23rd, you're quite right, yes. If I could have Exhibit 2101 produced, DSS.5023.0001.1305. We've moved from January to February here, and again, this is just for context. On Thursday, 26 February, Ms Halbert, you were copied into an email which attached a revised new draft brief to Minister Morrison, and the communication that Minister Morrison had indicated that he wanted a number of potential proposals in the attached briefing to be brought forward in his portfolio budget submission.
Yes.
And Mr Kimber had reiterated at that point in the fourth line, if that could be called out, commencing PAYG cleanup, that there were potential legal issues with this, and we need to tease these out more specifically over the coming days. Do you see that?
Yes, I do.
And that Mr Kimber's email in the first dot point below, according to his understanding of the process, was that DHS were going to draft descriptive words around the proposals, although there appears to be a question in the middle of that point, is that possible in the time frame? And his position that he had reiterated that the PAYG cleanup proposal needs to have appropriate words re potential legal risks / retrospectivity. And that again reflected the DSS position at that
That's right.
If I could ask that Exhibit 2103, DSS.5023.0002.2176 be placed on the screen. Ms. Halbert, you can see in the bottom part of that page that on Wednesday, 4 March 2015, you received the DHS NPPs for inclusion in the 2015-2016 portfolio budget submission.
Yes, and I think I mentioned in my statement that I'd seen that at one point, and there was one that I might have missed, and this might have been the one, but I think I was copied in for information, excuse me, but there were small parts, I'm no longer in the Dep Sec role.
That's right.
And there's small parts of this combined package that pertain to my substantive job.
That's right. And as you indicate in your statement, you cannot recall opening the attachment, strengthening the integrity of welfare payments?
I might well have, but I just don't recall.
And you don't have any recollection of reading it?
I don't have a recollection, and I would have read the bits that pertain to me, of course, but I may not have read that.
I ask that Exhibit 2146, that is DSS.5023.0002.2195_R. This is the attachment, Ms. Halbert. Thank you. And if we go to page 2196, underneath the last redacted passage commencing DHS, thank you. If you had read the attachment, Ms. Halbert, this is what you would have read.
Yes.
And no doubt you've read this in the course of preparing for your evidence. Would you agree with me that the attachment, as it was described as the DHS new policy proposal, reflected in the same basic terms the proposal that was considered by you in the week of 19, 20 through to 23 January?
At a high level, yes.
Yes. And particularly, it identified that customers would be required to confirm information the DSS held about them, that the targeting of historic overpayments due to incorrect income declarations would deliver unspecified amounts in debt and savings, that it would be based on analysis of PAYG data, it transferred the obligation to the customer, and if we go over the page, to 2197. Thank you, and just call out the top paragraph before the first redactions. Thank you. It is that it put the obligation on the customer to ensure their record is correct. It went on to insert that the new approach would not change how income is assessed or overpayments were calculated. But from that point on, what you understood to be the proposal and the number of interventions or the number of customers targeted was exactly the same as what had been addressed in the January advice.
I think I would not have such direct knowledge, but on the face of it, yes. Yep.
Despite the sentence there that the new approach will not change how income is assessed or overpayments are calculated, in your preparation for your evidence here, on reading that document, you don't see that there's any material difference in the concepts of retrospectivity or income smoothing in terms of the process that was proposed and considered in January by yourself and others.
On what I'm reading here, I can't tell.
Yes. There doesn't appear to be any change in the substance of the proposal, despite the words in the first dot point there and about the process not changing.
On the surface of it, it is largely the same proposal.
Largely the same proposal, yes. We move forward then to January 2017. You became involved in the Ombudsman's investigation.
That's right. I was acting Deputy Secretary at the time, but just before Christmas in 2016, I think, I took on the responsibility for this debt and compliance policy function.
Because of a way in which the allocation of responsibility was redivided.
It was a restructure, basically. Yeah.
A restructure within DSS.
Right.
Yes. And so you came into that role in December 2016.
Yes.
And at that point there was very significant media attention in respect of...
I believe it was starting.
It certainly gathered full steam by January.
Correct.
Following the Christmas break.
That's right.
And in that context, with that additional responsibility, you became involved in the Ombudsman's investigation. I'd ask that Exhibit 2104, DSS.5023.0002.2174_R be placed on the screen. Thank you. When you became aware of the Ombudsman's investigation, there was effectively an internal informal investigation to go back and figure out what had happened, which allowed the proposal, as it was considered in January 2015, to be implemented as a budget measure and rolled out as predicted under the new policy proposal.
Broadly, that's what we were just trying to work out what had happened.
Yes. And one of the pieces of information that was prepared in the process of trying to work out what happened was that Ms McGurk appears to have contacted Mr Kimber and asked him what his recollections were, and he put them in this email.
That's right. We just didn't have many staff on hand who had a memory of this.
And what Mr Kimber put into this email, which was copied to Ms McGurk and yourself, together with Ms Wilson and Mr McBride, was the background and a particular meeting on 27 February to his recollection.
That's right.
If the background and the content of the 27 February meeting could be called out, please. Thank you. The background there, Ms Halbert, reflects what at least you probably recalled at that time about the DSS position in respect of the proposal as it related to income smoothing and retrospectivity.
I'm not sure I understand what the question was, sorry.
Well, as Mr Kimber describes the background,
Yes.
DSS had provided commentary to DHS in January and February 15 that the proposed method to use annual income to calculate and raise a debt was not likely to withstand scrutiny, and if it was to be used, then legislative changes would have to be made. And he goes on to explain why. But at least insofar as he describes that, I'm suggesting that was consistent with your memory of the DSS commentary to DHS during that period in time.
Oh, yes.
The 27 February meeting that he's described, and I don't think you attended that meeting.
No, I don't believe so.
Involves Mr Kimber and Mr McBride, and of course 2 persons from DHS, Mr Withnell and Mr Britton. At that meeting, there seems to be communication orally that the new approach would use newly available data sources and analytical tools such that it would not change how income is assessed or overpayments were calculated, putting to one side the fact that that didn't explain what was going to happen rather than what was not going to happen. It continued that it had the following components. DHS would target identified discrepancies based on PAYG files obtained from the ATO, compared with reported earnings data that DHS held. Stopping there, in respect of that dot point, that resembled the proposal that was considered by DSS in that week in January 2015.
I understand that was simply identifying a discrepancy, not raising a debt or anything.
Certainly. The second dot point is where a significant discrepancy is detected, the information would be presented to the recipient. If we pause there, at least that had similarity to the proposal considered by DHS in January 2015.
I believe so. There may be nuances in it, but I believe so.
Yes. Well, really I'm drawing on the point that the information would be presented
That's
to the
correct. I
customer.
mean, that's important, yeah.
And the customer would be given the opportunity
That's
to
right.
comment.
So the information hasn't yet been used. The customer's able
Customers given the opportunity to respond as it was set out in the document I took you to first.
That's right.
This would not be a debt notice, but rather a recipient would be afforded the opportunity to explain, correct, update or challenge the information. Again, that mirrored the opportunity as it was described in the notice.
Without trying to be difficult, I've at that point, if we're talking about 2015, I probably didn't have that level of detail around exact steps. You know, the meeting that I attended in 2014 didn't go into that level of detail, and even in the comments that we were making, that this was an important point, that the ATO information not be used to raise a debt, but I probably didn't have that level of detail around what opportunities the customer would be provided with, etc. In 2015, I came to learn about that in more detail in 2017.
Well, I suggest that you did have that level of detail in 2015 because it clearly said so.
Look, as I say, I'm not trying to say I didn't. I'm just saying if there's nuance under that, it was important that the customer have the opportunity to provide further information. That I recall that from 2015.
Yes, that's right. The opportunity which is described there, that is the presentation of information to a recipient, them being afforded the opportunity to explain, correct, update or challenge the information, was in broad terms no different to the proposal that was considered in the week of
That's probably right.
January 2015,
Possibly.
where it said the customer...
Sorry?
Thank you. Where it said the customer will have the opportunity to update the information prior to it being applied to their Centrelink record.
Yes.
Yes. The third dot point, as Mr Kimber recalled the meeting, was that any subsequent debt raised would take into account the information provided by the recipient. Again, that was no different to the proposal considered in,
It's an element of the original, yes.
it was a part of the original, yes. And DHS also advised that there would be no change to how income is assessed or overpayments were calculated as part of the proposal. If I pause there, you'll recall I just took you to the MPP, which was copied to you on 4 March 2015, which used those same words, but which you considered didn't change the substance of the use of income smoothing or of the retrospective application.
Well, I think DHS was saying that there would be no change from previous practice in terms of how income is assessed or overpayments calculated. So despite this proposal, and this is my interpretation of this email, I wasn't there, they were saying despite this proposal, we haven't changed the way we calculate debts and raise overpayments. So,
Right. Okay. I might just clarify what your understanding of that meant in a practical sense. Did you understand that representation, no change to how income is assessed or overpayments were calculated, to be we're not going to change in a fundamental way the way in which we calculate debts by income smoothing, or alternatively, is it your understanding that income smoothing was always used to calculate debts and that meant there was no change?
I don't think I had that level. I don't think I was familiar with what DHS was doing in regards to all debts before I got the function in 2017. But on my reading of it, I would say that they're saying, despite this proposal, we will continue to assess income and overpayments on the same basis we have previously, whatever that was.
Whatever that was. And there are two options. One is that income smoothing was always used to calculate debts about which you had given advice, or that there was a misrepresentation and income smoothing was now being used. That hadn't occurred previously.
Well, look, I wasn't there in this discussion, but I don't believe we as a department knew about income smoothing being used on a broader basis.
That is, but on a broader basis prior to the proposal.
To this proposal.
Yes, that is, prior to 2015 you were not aware of income smoothing being...
No, so we would have assumed that the normal method, whatever that was being used to raise debts and would continue to be used.
That is a method which did not involve income smoothing.
Not involving income smoothing to raise the debt, correct?
That's right.
Income smoothing would be a source of information. Not income smoothing, the ATO data would be a source of information.
That is a trigger for a manual
An
investigation.
investigation of some description.
Right, okay. And so, building on that then, your understanding of what was represented to Mr. Kimber and recorded by him was that ATO data was, under the proposal, to be used as a trigger for an investigation.
That's my understanding.
That is, that part of the proposal which indicated that income smoothing would effectively be the default position was not part of the final measure as implemented.
And that was critical as far as I understand.
It was critical, yes. We could go then down to the next paragraph commencing subsequent to that meeting and call that out. Thank you. Mr. Kimber refers to the email on 4 March, to which I took you to, which included the reference to DHS advising the new approach would not change the way debts are calculated. And you've given evidence of your understanding, at least in 2017, about what that meant. But you don't recall reading the NPP in 2015.
I don't recall, but that's not to say I didn't, but in 2017 I had this understanding.
Yes. if we go back to Exhibit 2107, DSS.5023.0002.2172_R, you can see that one of the emails that Ms McGurk obtained as part of looking back to figure out what had happened was the policy advice from Mr Mason to Mr Whitecross and Mr Joyce in an email Friday 16 January 2015. Do you recall being provided with a copy of that document in January 2017?
I'm not sure if I saw this email, but I believe I saw the advice, well, at some point saw the advice from David Mason, but I'm not clear when that was.
When you did it, all right. We go over to the second page. I'm probably more interested in the substance of the advice and if DSS concerns could be, thank you. Again, to the extent that you may have become aware of this particular email in 2017, it contained effectively a repeat of the issues about income smoothing that were identified back when the proposal was first considered in 2014, 2015.
That's right, but sorry, is this advice from Mr Mason in 2017 or?
No,
No,
Mr Mason in 2015.
So this is the same kind of concerns that we had.
It's the identical concern then, which was brought front and centre, as it were, at least in Ms McGurk's mind and potentially yours, in January 2017. Yes. Now, could we please go to Exhibit 1393, DSS.5023.0002.2547_R. This was an email from, or this is an email from you to Ms Wilson, 1 March 2017. The attachment is the combined 2014 and 2017 advice. We'll come to that shortly. But it was what you were setting out as the proposed response to the Ombudsman regarding the legal advice due today. You see that?
That's what they had asked a specific question of us and we were answering that.
And if we go over to page 2548, the specific question appears in the middle of the page. If the email, thank you. The request came from Ms McLeod, who is noted in the footer as the Acting Senior Ombudsman, and the request relates to the advice which appears in the Executive Minute briefing the Minister for Social Services dated 12 February 2015. This was a document of which the draft was considered by you in your final email to Ms Golightly on Friday 23 January 2015.
Yes.
And on page 10 of the document it states that there may need to be a change of policy and that DSS also advised legislative change would also be needed to implement the initiative. And what was asked by the Acting Senior Ombudsman was for a copy by 1 March 2017 of the advice from DSS and any other notes, documents or emails that relate to this advice. And so the proposed response that you drafted for consideration by Ms Wilson was set out in the body of the email.
That's
We return then to the body of the email on page 2547. We'll just deal with these paragraphs sequentially, but perhaps if the first 3 paragraphs could be called out. This is how your draft was. And I'll just ask you to peruse that briefly. But in essence, do you agree that you repeat in the first two paragraphs the position as it was communicated to DHS in January 2015?
That's the case, yes.
Yes. The last sentence of the second paragraph is that it is understood that DSS also indicated to DHS that legal changes would be necessary to allow the measure, as DSS understood it at that time to be implemented. Again, that reinforces the DSS position at that time.
Yes.
And the first sentence indicates that following this, DHS took DSS concerns into account and made adjustments to the process. Now, what adjustments to the process did you understand were made by DHS when you make that sentence? When you craft that
Well,
sentence?
from our research, so to speak,
From your research, yes.
at the time, so we understood that DHS had put several steps in place between the availability of the ATO data and the eventual raising of a debt. So there was, our understanding was that they had broken the nexus between the availability of the ATO data and the raising of a debt through this putting in several steps, enabling the customer to provide information, etc. So that was our understanding of the difference. It wasn't just giving the customer an opportunity, it had to be every opportunity and easy to do that, easy to provide the information, etc. There was a whole range of different steps that they had put in place, or it explained to us that they had put in place that we felt had broken that nexus.
Just so I can understand that, when you say you thought they'd broken the nexus between the ATO data and the raising of the debt, you understood that the ATO data would not be relied on to raise debts?
That's correct. It would be a source of information that might contribute to a debt being raised, but it would not be the cause of the debt being raised. It's still a source of information that's available that can be used, but it's not to be used to raise a debt without these other steps being in place.
And what are the other steps?
So it's the opportunity for the customer to provide information, but and this is on my knowledge I gathered in 2017 rather than, you know, current knowledge as this was being done. But when it was first implemented, or at some point in the implementation, there was no phone number on the letter for the customer to provide this information. What was online compliance initiative, I think, whatever that was called, system was very hard for people to access in some ways. It was not easy for people to provide this
You
alternative.
may be getting off point a bit.
Oh, sorry.
I'm just trying to understand, how do you break the nexus between the ATO data?
Well, it was by them.
Hold on a minute. ATO data and the raising of the debt simply by allowing the customer to give some information, because clearly if the customer doesn't do that, you're going to have the correct connection between the ATO data and the raising of the debt still in existence, aren't you?
My understanding was that DHS was going to take every possible step to enable the customer to interact with them. I think they did make changes, or they were telling us about these changes, but for us it seems that the debt would not be raised unless the customer failed to engage, and this was after DHS had put in place steps to make sure that vulnerable customers, people had changed address, all sorts of things, people who would not have, you know, got the notification or wouldn't have had the opportunity. DHS had put steps in place to make sure that they had every opportunity. They could contact DHS directly rather than being forced into the online environment, etc. And only if there was no other information available, and this was the 2017 legal advice said this to us.
Okay, when did you get all this information?
This is information that DHS was providing us at this series of meetings, I believe, that we
In
had
2017?
in 2017.
Okay, thank you.
You say by early 2015, DSS gained a better understanding of how the revised process would satisfy the legislative requirements. Now, the legislative requirements that you refer to there is the requirement to calculate actual fortnightly income before a debt could be raised, correct?
That's my understanding, yes.
Yes. In particular, DSS understood that the intended implementation model provided recipients with the opportunity to correct any information presented to them based on ATO data matching, particularly smoothing of income data obtained from the ATO. If we pause there, that opportunity to correct any information presented to them on ATO data, particularly smoothing of income obtained from the ATO, was part of the proposed draft of the executive minute on which you advised in the week of 19, 20 and 23 January 2015, wasn't it?
I would say that's correct, that there had to be a real opportunity, and I think in the course of our investigation we had come to the understanding that there had not been real opportunities for customers to provide this information.
But the legislation that you're considering here doesn't address the question of opportunity. It addresses the question of proof of actual
Look,
income.
I understand that.
Please let me finish.
Sorry.
The legislation you are considering here addresses the question of proof of a debt by reference to actual income in any given fortnightly period, correct?
That's right.
And that the position of DSS in 2015 was that averaged or apportioned or smoothed income from PAYG data was not sufficient evidence of actual income in a fortnightly period, correct?
That was our original position, and in light of the 2017 legal advice, also the explanation from DHS, we came to understand that the ATO data would not be used to apportion income over fortnights unless there was no other information available, combined with the fact that there was a likely overpayment. So it may have been incorrect assessment on our part at the time, but that was the conclusion we came to once we had that legal advice.
Ms Halbert, that was your original position. What you represent in this paragraph is that it changed in early 2015, not as a result of the 2017 legal advice.
So that's where my understanding is coming from.
Yes,
In
well, you just told-
2015, I believe that understanding came from the meeting between DHS and DSS.
But you weren't in the meeting.
No, I wasn't. No, this was the information
didn't
being
have-
provided to me. Obviously, I'm talking about an historical event here, so the information's been given to me by the people who had that information.
What you described then in your answer is not contained in Mr Kimber's summary to you in 2017, is it? This last resort concept and the application of income smoothing.
No, I don't believe we had heard of the last resort
No.
until 2017.
So how could you possibly represent that by early 2015, DSS gained a better understanding of how the revised process would satisfy legislative requirements?
Well, my recollection is that I have received this information from others, and that we came to that conclusion prior to the new policy proposal being finalised, that DHS had changed their approach such that this was not first-hand knowledge on my part, but they had changed their approach such that we felt it satisfied the legislative requirements.
But the legislative requirement is about proof of actual fortnightly income by reference to averaged income. That's the point, isn't it? So it doesn't matter when it happens, it didn't satisfy legislative requirements.
The basic problem was always that if you are on a fortnightly income tested payment, that's the income that you must declare.
Yes.
And the ATO might have data that relates to the whole year, but you may not have needed to declare that income because you're on a fortnightly payment. That was the underlying principle of it. In 2015, the department came to the understanding that DHS was not using the annual ATO data to raise a debt pertaining to fortnightly income. But I don't know the detail of how they came to that understanding, but it was repeated in a much expanded form to us in 2017.
By DHS, you're talking about now, right? Well, what you represent in this paragraph is what I'm saying is inaccurate.
Well, I believe the people who gave me that information considered that to be an accurate statement of what they came to conclude in 2015.
Who are you crediting with having given you this
Oh,
information?
look, I couldn't tell you exactly, but it would have been the area. So following our inquiries with Mr Kimber, for example, he provided us with some information and we would have delved more deeply into that.
Okay, what you're representing here is that in early 2015, once you were told that customers would get the opportunity to correct information, you thought that data matching, smoothing of income data was fine and no legislation would be required. Isn't that what you're representing here?
Look, I don't believe that's what we were trying to say. We believe that, well, the department believed in 2015 that DHS was not going to use the ATO data to do income smoothing, and I can't tell you the details of those discussions, but in 2017, when many more changes had been made, the same argument was put to us.
Look at the words here, please.
Yes, I
Ms.
do
Halbert.
see that.
By early 2015, you got a better understanding. You understood that the model provided recipients with the opportunity to correct information based on ATO data matching, particularly smoothing. As such, DSS no longer considered legislation would be required, and advice regarding specific legislative changes were not sought. That's simply untrue, isn't it? DSS didn't come to that view
Well, it
in
may be-
2015 or express it.
It may be badly worded, Commissioner, I don't know, but I don't think particularly smoothing of income data from the ATO is an endorsement of smoothing income data.
What's being said there is that DSS formed a view that legislative change was not required
I'm not-
in relation to smoothed ATO data averaging, provided there was an opportunity to correct information. Once you were told that an opportunity would exist, DSS was fine with the concept. That's what's being said
That is what
there,
is
isn't it?
said there, yes.
Okay, it's untrue.
I,
Do you say that DSS
Given that
did
it
come
says-
to that view, that it expressed that view anywhere we can find?
well, that is the view that was expressed to me, and
By
that,
whom and when?
well, I believe it was in that email from Mr Kimber. I don't believe I knew in detail that we had moved to understand that this proposal in 2015 didn't need legislation. So I'm commenting on things I wasn't involved with. But that is what I was told, that DSS had in 2015 come to this understanding that the way DHS was proposing to implement the proposal would no longer require legislation.
That's a different thing, because if DSS is told we're not smoothing, we're not averaging, or given to understand that, then they might well say no legislation is required. But this notion that they're told, yes, averaging is happening, but it's okay, there's an opportunity to correct, and they say, that's fine. Can you point us to any shred of evidence that that ever happened? Do you assert that you were told that's what happened?
I do not assert that I was told that that happened, but that is my understanding of what the department came to understand
In 2015?
in 2015, and I don't believe I was involved in that.
And how did you come to understand it?
Via the research that we did in 2017,
Right, what in that research
to look
led you
back at what had happened in 2015.
Right, what? What
So-
in the research?
So the
led you
only
to view?
document I believe I've seen in this, or the documents that I've seen in this exercise, is the email from Mr Kimber that told us what had happened in terms of the change in the DSS position, and by then, by the time we're writing to the Ombudsman, we had the 2017 legal advice that was a similar, but as I tried to describe before, a much different proposal at this point, but based on the similar thing that as long as the ATO data wasn't being used directly to raise the debt, but this understanding in 2015 is a second-hand understanding on my part.
Okay, can we get the Kimber email?
Exhibit 2104 DSS.5023.0002.2174_R. Thank you.
Now, can you just point me to where there's some indication in there that DSS reached the view that if an opportunity was given to customers to correct information, averaging was not a problem and no legislative change was required.
No, it talks about the way debts are calculated, which is, I think, the same thing.
Just where, can you tell me?
Sorry, under subsequent to that meeting is the beginning of that paragraph.
DHS has advised that this new approach would not change the way debts are calculated. And that led you to the conclusion that DSS formed the view that legislative change was not required in respect of an averaging process if an opportunity was given to customers.
So
This is nonsense, isn't it?
Well,
Halbert?
look, I'm not trying to talk nonsense to you, Commissioner. Back in 2015, and as I say, this is second-hand information for me, DSS came to understand that, well, I don't know exactly what they came to understand, but that the way debts were calculated, i.e. on a fortnightly basis, would not change.
Okay.
So
All right.
that was the understanding that
Sure.
was conveyed to me from 2015.
Okay, that's completely different from we will be using averaging, but we'll give them a chance to correct the information.
I don't read it like that, and that's not what, as I say, maybe it's not well worded, but that is not what we understood from DHS in early 2017. That's not what we were trying to convey, that income smoothing was okay. And I might also say that we were also, while formally responding to the Ombudsman, we're also in discussions with them about this, trying to share with them what our understanding of the current DHS position was. So we had various communications with them about it.
Yeah, and here you're telling them of what DSS's understanding was in 2015, which bears no resemblance to the position DSS actually took in 2015, does it?
As far as I'm aware, by the time the MPP was finalised, that was DSS's position,
That, and I'm
that they were
sorry
not
to repeat
changing
it
the way
again,
that debts were calculated.
that they what? So,
But were not changing the way that debts were calculated.
but look, that's not what you're saying here. DSS could have said to the Ombudsman, look, we've been had, they were averaging, they gave us to understand they weren't, so it's a surprise to us. Because
We
that
had
was the
conversation,
position,
I
wasn't it?
believe. We had that conversation, I believe. We were being quite open with the Ombudsman's office. We were both looking at the same thing at the same time, trying to work out what had happened. And in the Ombudsman's report, I think they found that DHS were doing a whole range of things in the implementation that were not consistent with the rights of the customer, etc. We were coming to the same conclusion, so we were having an open conversation about this. If the response was badly worded, I'll take responsibility for that, but I don't believe the Ombudsman's office would have been surprised to receive that response, nor the eventual letter, because of the conversations and interactions we were having with them while investigating this situation. But I'm not speaking on their behalf, I'm just saying that's my understanding at the time.
Ms Halbert, can I put one interpretation of events to you?
Yeah.
That is that DSS in 2015 very firmly said that averaging was not within the legislation. The rate calculator required actual fortnightly income to be the basis of assessment of entitlement. That was firmly conveyed to DHS.
That's correct.
DSS then, perhaps turning a bit of a blind eye, came to believe that averaging would not be used because DHS kept saying we're not changing the basis on which we calculate entitlement or overpayments.
So, Commissioner, there was no blind eye whatsoever. I mean, I had no skin in this game in 2017. We were faced with a situation where what was being reported in the media largely, but then of course we would have had other sources of information from investigating, that what had been implemented was not, and I had to do some research to piece this back together because I'd been out of it for a couple of years, but we came to the conclusion that what DHS had implemented was not what we had thought they were going to implement.
Okay, well, to put it perhaps more neutrally, it came as a surprise when you were briefed by Ms Golightly in early 2017 to find out that they'd been averaging.
Correct.
And that was in the context of a media blow-up about people getting these debts.
And the
And
Ombudsman's investigation.
Sorry?
And the Ombudsman's investigation.
And the Ombudsman had started an investigation. This is a context in which government ministers have already gone out in support of this program and asserted that everything's fine, nothing to see here. Is that correct?
From my recollection, ministers were in the media about this.
Yes. And so DSS is then in this position where they now find out there has been averaging all along, and they have two choices. One, they can be open with the Ombudsman and say, this is a surprise to us, we don't regard it as within the legislation. We told them that at the beginning. That's one option. And the other option is to try and come in behind DHS and find some legal advice which would provide some possible excuse for this.
No, we were not looking for an excuse for DHS, and I would have to say I was not involved in the 2015, change of approach, etc. But there was certainly anger. I mean, there was anger at what we were finding out. It was not just a surprise that people in DSS believed that they had been given assurances in 2015 about the way this would be implemented, and that appeared in 2017 to have not been the way it was implemented.
Accepting that, this paragraph in your email for the Ombudsman is just not true, is it?
I haven't got it back in front of me, sorry, Commissioner, but
Okay,
it was, if it didn't read correctly, it was not intentional. We were not trying to hide this from the Ombudsman, and from memory, I think the 2017 legal advice said not that income smoothing was okay as a concept, but if the annual amount of income was the only source of information available to the Secretary, I think it is, that the Secretary could use that information if there was no other information available after many steps being, that the Secretary would need to act on that information in some way.
that is just not reconcilable with the 2014 advice that averaging didn't fit within the legislation, is it? Last resort makes no difference.
Well, I don't think we thought they were connecting the use of the annual information directly to the raising of the debt. We may well have been mistaken in our understanding at the time, but I'm just trying to convey the impression we were not trying to hide this from anyone, and we were in a very open process with the Ombudsman about it, and the response that we gave to them in the end was meant to convey that we had been satisfied that they had taken enough steps to implement the thing that we thought originally would have satisfied the legislative requirement. That is the understanding we had in 2015.
In 2017, it was a total surprise to you they'd been averaging.
It was.
Where'd you say that to the Ombudsman?
Well, I don't. We had many meetings with the Ombudsman. I don't know whether I said it was a total surprise, but we certainly did not realise. So what we found, I believe from memory, it came up in the context of OCI, but possibly at a meeting on the 18th of, January, when we were had just met with the Ombudsman. I think DHS then revealed that they had been using this more broadly than the OCI, and that also was a complete surprise to us.
Well, just going on with one possible interpretation, it is that having found this out, you then went looking for some legal advice which could support the business case for this.
No.
And that's what Ms Pulford's advice represents.
The reason that we sought the legal advice, from my recollection, is because DHS had put this case to us. Now, again, we may have been incorrect, but on the basis of our understanding that the nexus was broken between the data and the debt, that we... And I've lost my train of thought there. Can you just ask me the question again?
I had suggested to you that Ms Pulford's advice, which in fact doesn't address
the reason for getting the advice was that we felt that DHS possibly could be able to do this thing that they were doing, not using the data to raise the debt, but as the last resort source of information. We came out of that meeting.
Sorry, can I stop you? When you say not using the data to raise the debt, but as the last resource source of information, how is that not using the data to raise the debt?
Well, look, me sitting here in 2022, it is more difficult for me to explain how we came to that conclusion, but we did. And we came to the conclusion, and the reason that we sought the legal advice, as I was saying, was because we felt that we were going to have to accept this DHS position. We felt it was a different thing than we had got legal advice on previously, and we had to get the legal advice. That was the only reason we got it.
Why was it different? You'd got advice about averaging, and they were averaging. So, and this is advice about averaging, which doesn't address the requirements of the legislation.
Well, I can only repeat, Commissioner, that we were convinced at the time that there were sufficient steps and distance between the availability of the ATO data and the eventual, if ever, raising of a debt, that it no longer was in breach of the legislative requirements. But a subsequent court case possibly showed that we were wrong, but we were not trying to hide anything.
You must have understood that here's the ATO data, customer doesn't respond, it's going to be used to raise the debt. If the customer responding is the only thing between the ATO data and the debt raising.
Well, that would be with multiple attempts on DHS to contact the customer, and the customer genuinely having had an opportunity and not taking up that opportunity to engage. DHS then has information available to it that suggests an overpayment. If they've made every attempt and the customer has declined to provide alternative information and understands that if they don't, that information will be used to raise, to do this, apportioning or whatever, only in that circumstances could that debt be
The
raised.
ATO data will be used to raise the debt.
But or based on as I understand it now, and it's quite a distance for me, it's based on the fact that the secretary had information available to her or him that they must act on in some way, and have tried to, enable the customer to correct that information, provide additional information, have the debt, have the correct situation about their fortnightly income established, and no debt would ever be raised. But if none of those approaches from DHS were responded to by the customer, the secretary had information available that she or he must act on in some way. That was more my understanding of what the legal advice was telling us.
Yes, all right, thank you.
Ms Halbert, you've said here that there was surprise and anger within DSS in January 2017 once it was made plain that averaging was being used in the calculation of debts.
That's right, that's my recollection.
That surprise and anger reflected the fact that clear advice was given by DSS in 2015 by you to Ms Golightly that was not permitted according to law.
That's right.
What you represent in Exhibit 1393 is the opposite of that, isn't it?
I haven't got the exhibit in front of me.
Exhibit 1393 could be produced. DSS.5023.0002.2547_R. This is your draft letter to the Ombudsman addressed to Ms Wilson, the Deputy Secretary.
Yes.
And if we pull out the two paragraphs commencing following this and a key difference, what you represent in your draft letter to the Ombudsman was that, in fact, DSS came to a view in 2015 that legislative change was not required for the application of income smoothing.
I'm not sure that's what we were trying to say, but I believe that we thought...
I'm not asking you what you believe, I'm
No,
asking
okay.
you what you represent.
Right, I understand what you're saying.
My question is, you represented in your draft letter to the Ombudsman that in 2015, DSS came to the view that after a customer had been afforded an opportunity, legislative change was not required to create a debt by income smoothing. That's what you represent.
That is what that says.
That's what you
I've
represented.
tried to explain the way we came to understand that, but I don't believe we were endorsing income smoothing as a concept.
You represented to the Ombudsman a position which, to your surprise and anger, was not true.
Well, I'm not sure what more I can say. This sentence says
You could accept the proposition.
that we understood, well, I mean, it's shorthand. The opportunity to correct any information is actually a series of, not just an opportunity to correct any information, but a series of steps to ensure that they had every opportunity and were helped to correct that information. And as I just said a little while ago, I understood, and this perhaps is not a well-written sentence, that if the secretary still had that information available to him or her and no other information was forthcoming from the customer, they would act on that information. And my recollection is, and that in that case, that the income could be apportioned over the year in lieu of any other information provided by the customer. That I'm not trying to defend that position, but that is the position we came to in 2017, and that is what we conveyed, maybe not very well, to the Ombudsman, but our conversations with the Ombudsman would have been conveying that impression, because that's how we were coming to that conclusion, and that's the conclusion we came to. And if you look at my statement, I think it's in my statement, this was a major issue for us, but after having talked it through and got the legal advice, etc., we moved on to several of the other egregious elements of this implementation, and we're really focusing on getting them in a position where they were lawful. So it wasn't that we were trying to cover anything up. We somehow came to this conclusion in 2017, and as I say, moved on to other elements of the whole package that really needed to be addressed.
The problem is, you say in this that it's a conclusion you came to in 2015.
So I didn't come to the conclusion in 2015, but it was put to me that this is how that conclusion was reached. But I was coming to it separate to that, from research that we were doing at the time and getting the new legal advice. So I wasn't basing my 2017 opinion on the 2015 opinion, but we needed to explain to the Ombudsman how we'd got here.
Ms. Halbert, you keep slipping back into what you believed to be the case in 2017 after multiple conversations and legal advice. My questions to you are focused on what you are representing to the Ombudsman in this draft letter in a response to their very specific inquiry, which you will recall was produce a copy of the advice from DSS about the legislative change that would be needed and any other notes, documents or emails that related to that advice. That was the request that you are responding to.
Yes.
And in your response, drafted by you, submitted to Ms Wilson, you represent to the Ombudsman in these two paragraphs that DSS became comfortable with the concept of income smoothing after an opportunity was provided to a customer in the creation of a debt. That's what you represent in these two paragraphs.
When I read that sentence, I don't think it's even that clear. And all I can tell you is that we were not endorsing income smoothing as a concept. We were, I won't use the word reluctantly, but came to accept that if no other information was available to the Secretary, that this information could be used in that way. So I can't really give you any more information than I'm giving you. That is the conclusion that we came to in 2017.
You keep going back to 2017. I'm talking about what you're representing about the position in 2015. So please listen to my question.
Okay.
I know what you want to say about how things changed in your mind in 2017. I'm talking to you about the position you represented to the Ombudsman that DSS held in 2015. And you can see in the first line, you say by early 2015, DSS gained a better understanding of how the revised process would satisfy the legislative requirements. I'll pause there. Do you agree that you are representing the 2015 understanding of DSS about the proposal to the Ombudsman in these two paragraphs?
Well, I'm not sure if the second paragraph is referring, oh, it is still referring to 2015, yes.
Yes.
I don't know what more I can say. This is the position that was given to me and I have represented it in this email.
Do you accept that you are representing the 2015 DSS position in respect of income smoothing to create debts to the Ombudsman in these two paragraphs?
I don't think that's what it says.
Well, can you point out where you're talking about the
I think
2017 position, please?
Sorry?
Can you point out where you are talking about the 2017 position?
Not in these paragraphs.
No,
I was
my question remains, do you accept that in these two paragraphs you are making a representation to the Ombudsman about the 2015 position held by DSS in respect of income smoothing?
We are putting the DSS position. I don't believe it says that income smoothing is a appropriate method of raising debts. It says that if the customer was provided with the information, particularly if the ATO data matching information was available, particularly smoothing of data obtained from the ATO, if the customer, when I was talking about the 2015 proposal before, if the customer had every opportunity to, as I've been through a few times. So I think that's what it's saying. If it's interpreted as an endorsement of income smoothing, then that is a badly worded email, because I don't believe that's what we were doing.
Ms Halbert, I don't know if you're doing this deliberately or not.
No, I'm not.
That is beside the point. The point is that you're telling the Ombudsman in 2015 DSS was satisfied with income smoothing as being within the legislation on the basis of an opportunity to correct information. You are on affirmation. You are required to tell the truth.
I'm attempting to tell the truth, Commissioner.
Did you seriously have any basis for saying that in 2015 that was DSS's position?
I don't believe that we were endorsing income smoothing in
You
these
are
two
not answering the question.
So-
It's not about whether you're endorsing income smoothing. It's about whether you were telling the
I was
Ombudsman.
telling the Ombudsman the conclusion we came to in 2015, which was that the way that we understood it was going to be implemented, legislation would no longer be required.
Which was on the basis that customers would have an opportunity to correct information in the event of income smoothing. Yes?
Customers would have the opportunity well before any attempt was made to do income smoothing.
And that you represent as DSS's position in 2015.
That is what that says.
Yes. Now, is this just an attempt to reconcile irreconcilable legal advice as the 2014 advice, which you had to hand over to the Ombudsman, and the hastily procured 2017 advice, which said something quite different?
That is not the spirit in which we provided the advice to the Ombudsman, I can say that.
Sorry?
That is not the spirit in which we provided the advice to the Ombudsman. We were having an open conversation and we were trying to be helpful, and we had obtained this 2017 legal advice in the circumstances I think I described earlier, and the question they were asking us really required us to provide both sets of advice to show the difference in thinking.
Okay, I've got one more question, then I'll leave Mr Gregory in peace to ask his questions. Were you giving this response at anyone's direction, or is this your own idea?
There was a central ombudsman place in that department, and the Ombudsman's request had come into that area, and they'd sent the request to me, and so we started drafting a response.
And so this is your own doing? Nobody told you you needed to come up with something like this?
No, but someone in my staff would have drafted it, and they would have drafted it based on getting information from the people who worked on it in 2015. So there was no direction or anything like it. We'd had a request from the Ombudsman. We were responding to a request from the Ombudsman.
Thanks. That's me done. Thanks, Mr Gregory.
Thank you, Commissioner. Sorry. Ms Halbert, the point you're making is that you made this representation about the 2015 position to the Ombudsman of your own volition.
Yes.
You accept, given your earlier evidence about the opportunity being included in the proposal which you advised against in 2015, your evidence about Mr Kimber's email informing your state of mind in 2017, that income smoothing would be used as a trigger, not in terms of calculating a debt, and your evidence that there was surprise and anger by you and others in DSS in 2017 that income smoothing was being used, contrary to your understanding, that you are representing a false position as at 2015.
Look, I don't think I can answer that because I was in no way trying to present a false impression of anything. And I was passing on an understanding that the department had in 2015 as it was presented to me, I presume. I don't know what more I can say about it.
Well, do you accept that in 2015 you understood that there was the opportunity by the customer to be presented with ATO data before a debt was raised?
Yes, but we had since found out that those opportunities were extremely limited and were not real opportunities.
But it didn't matter whether there was an opportunity or not in the context of the legislation about which you gave advice to DHS in 2015, did it?
Well, sitting here today, I find that hard to explain, but in 2015, whatever was explained to DSS by DHS led DSS to understand that income smoothing would not be being applied routinely as caused by this availability of ATO data. And based on that, I have conveyed that to the Ombudsman. So I'm a little affected by the suggestions of deception. There was no deception. If we haven't conveyed the concept correctly, then that's on us. But as I said, we had been talking with the Ombudsman. We did not, and between January and this email being sent, DHS had further made several changes to what they were doing that further gave us, well, that maybe they had already made them, but it was a series of meetings. They took us through a whole lot of changes that they had made that took us back to our original conclusion in some way, but much more strengthened. But it didn't change what DSS had come to the conclusion of in 2015.
Commissioner, I'm conscious that the witness has been examined for the last hour and a half. Might it be appropriate for her to have a few moments to collect herself?
Well, perhaps, but if we're nearly
I'm
finished,
okay, depending on how long they want to go.
how much more have you got?
A relatively short period.
Look, I think you'd probably rather get it over, wouldn't you? Or
Yes,
up to
yeah.
you if you need a break.
No, I'm okay at the moment.
I'll make my position unmistakably
Okay.
clear. Your evidence yesterday and today was that in 2015, DSS gave clear advice that the calculation of debts by reference to averaged PAYG data was contrary to the legislation. You accept that?
That's correct.
And the context in which you gave that advice included, as you have seen again this morning, DSS saying that the information would be presented to a customer in an online format with the opportunity for them to respond, correct?
Yes.
And irrespective of that, the DSS position remained that that was a fundamental change to social security law.
I don't believe we resolved from that original position, the way the proposal was put to us in 2014-15.
That's right.
I don't think we resolved from that position. But in 2017...
I'm not asking you about 2017.
No, well, even 15.
You're off the track again.
Sorry?
You agreed the context in which you gave the advice about the fundamental change to social security law included the presentation of information in an online format with the opportunity to respond.
Yes.
And to your mind, when you gave that advice, that included obviously a genuine opportunity, not a half-hearted opportunity or a difficult opportunity or a frustrating opportunity.
Presumably, yes.
Right. We move forward then to Mr. Kimber's email, and your evidence today was that you understood from what he represented to you in 2017 about the meeting he had on 27 February 2015 was that income smoothing was not going to be used to calculate a debt, correct?
That's what I understand. Yeah.
And that's why there was surprise and anger in January 2017 when you found out that after an opportunity, albeit a frustrating, difficult or challenging one, income smoothing was being used to raise a debt.
At that, in January 2017, yes, that's right.
You accepted that you are representing the 2015 DSS position in your draft to the Ombudsman.
Yes.
And the plain words of it indicate that by early 2015, DSS gained a better understanding of the process. The revised process would satisfy the legislative requirements. That's not true. The DSS position, as you have just said, did not change. You did not resolve from it in 2015.
Can I have that?
Exhibit 1393.
Just even if you just repeat the
sorry.
question.
By early 2015, DSS gained a better understanding of how the revised process would satisfy the legislative requirements. That's not true. The position was not resolved from in 2015, was it?
The original position was not resolved from, but
Okay.
in 2015, members of DSS staff came to the conclusion that DHS was doing something different from that original proposal, and that was how they changed their view, is my understanding of it.
Sorry, say that again.
That in 2015, DSS staff became convinced that DHS was not implementing the proposal as first proposed,
Yes.
that they were implementing something different, and that enabled them to come to the conclusion that legislative change was not required.
And that was because DSS understood it didn't involve income smoothing to create debts. You've given that evidence multiple times.
We never felt that income smoothing was an appropriate thing. Use of ATO data to automatically income smooth was never appropriate.
Right. But what you're saying in this paragraph is the opposite of that. DSS understood that the implementation model provided recipients with the opportunity to correct any information presented to them based on ATO data matching, particularly smoothing of income data obtained by the ATO. Your evidence was smoothing was off the table in 2015 as a result of the advice.
I'm not trying to resolve that. That sentence to me is not a well-worded sentence, but it said the customer has the opportunity to provide additional information, including in relation to, or specifically in relation to smoothing, but that's not saying that the smoothing should be applied. It may not be explaining myself very well, but that's my reading of that sentence. But I don't believe we were trying to unpick our original position, but the position had changed in 2015, once DHS explained to us a different proposal.
I'm suggesting that's contrary to your evidence yesterday and today.
Well, I don't believe in my evidence. I have tried to give a first-hand account of how DSS came to change their view in 2015. I'm relying on second-hand information to provide that to the Commission. I don't believe I represented myself as having a first-hand knowledge of that. I just am reading documents that explain it.
Well, this is contrary to your first-hand knowledge in 2015, isn't it?
But my first-hand knowledge in 2015 only went up to prior to DSS meeting with DHS and changing their position. So I wasn't involved in that.
We've just gone through the information after that,
Yes?
which was the 4 March 2015 new policy proposal, which if you had read, you said, would not change your position.
I'm just not sure. I'm just giving you an interpretation of that sentence as not an endorsement of income smoothing. That's all I'm doing now.
Yeah, that doesn't answer my question.
Well,
My question is, what you are representing there is a position that income smoothing was okay if someone was provided an opportunity, and that was the position as at 2015.
that was the position mid-2015. My advice is going to DHS were prior to DSS coming to this conclusion. So I'm not in any way trying to avoid the question, but I didn't change from the advice I was providing when we thought the proposal was in its original form. At some point after that, DSS became convinced that it was no longer in its original form and came to accept that it didn't require legislation. I'm not purporting to have come to that conclusion. I'm just relaying what I understood to be the position back then and tried to do that with the Ombudsman.
If Exhibit 1394 could be produced. DSS.5023.0002.2557_R. This is Ms. Wilson's response to your email. I'm happy with this, but can we use the term apportioning rather than smoothing in the third sentence of the third paragraph? Cheers, Serena. You see that?
Yes?
We go to Exhibit 1394, DSS.5005.0001.0534. And if the third paragraph of Exhibit 1394 could be pulled out following this DHS, thank you. You can see the word apportioning of income appears in the second last sentence.
Yes?
That is, you've made the change suggested by Ms Wilson,
That's right.
and the letter is forwarded from the DSS central area dealing with the Ombudsman.
That's right.
And again, it represents otherwise a representation about the DSS position in 2015.
Yes, it's the same that we're looking at.
It's otherwise the same letter.
Yes.
Ms Halbert, what in fact happened here is that you are giving evidence that you did not try and manipulate the truth to the Ombudsman, correct?
Yes.
When it is abundantly clear from your written words that you did.
Well, I was not trying to mislead the Ombudsman's office, and if I've written it incorrectly, that's my responsibility, but I was not in any way trying, and I in fact offered to meet with them after this email had been sent to explain our position.
You understood the importance of justifying the legality of the scheme to the Ombudsman.
I didn't feel any obligation to justify the legality of the scheme. What I was explaining to the Ombudsman was that the proposal, in our minds at that time, had sufficiently changed that it no longer was in breach of the legislative requirements. But that was the conclusion at the time.
It's not what you represented about the 2015 position, though, is it?
Look, I don't know whether people want to, give me a break, but I'm not. I am telling you, and I think I've explained it, but obviously not very well, that the advice I was providing to DHS, and others were inputting into that, was based on the understanding that the proposal was as it stood at the time. Further changes in DSS position I was not involved in at the time, and I was just trying to explain them. That's all there is to that.
The second part of the request, apart from the legal advice, was the request for documents, notes, memoranda relating to the legal advice.
Yes.
You had the opportunity to provide all of the exchanges between DSS and DHS to the Ombudsman, which surrounded the issue of legislative change and the creation of debts by apportioned income.
Yes, we did. I think they had access to those, though.
You were asked to provide it by the Ombudsman.
Well, if we didn't provide it, it was not from not wanting to provide it. I believe they had access to those other documents. Perhaps we didn't feel it was necessary, and perhaps we had a conversation with the Ombudsman's office about that, because once this email went, they didn't come back to us seeking further information, to my knowledge.
The question is, you were asked to provide
Yes, I
a
understand.
copy of any other notes, documents or emails that relate to the advice. That's what you were asked by the Ombudsman. You had the opportunity to provide all of the notes and emails that were exchanged between DSS and DHS in January 2015 about the effect of the advice on the proposal.
And I don't recall, but perhaps we didn't consider that.
You had the opportunity
We
to
had the
do that,
opportunity, and there was no reason why we wouldn't have provided that.
except unless you were trying to manipulate the truth
we
about...
weren't.
Please let me finish, because this is important to you. Unless you were trying to manipulate the true position about the DSS response in 2015.
We were not.
And that you did in fact not provide those because you were falsely misrepresenting the DSS position to the Ombudsman in your draft letter.
We were not, and I believe in the request from the Ombudsman's office, which is not in front of me, that they referred to some of those comments that we had made. Is that not the case? So they had access to those documents anyway. That probably informed our decision not to give them to them again. If there was a decision, we were certainly not withholding information from them. They must have had access to those documents to be asking us that question.
The basis on which the question was asked by the Ombudsman was the 12 February 2015 executive minute to Minister Morrison, correct?
Yes.
Right. They didn't have access to your emails,
I
did they?
no, and
They weren't provided, were they?
no.
No. You had the opportunity to do so and you understood it was a requirement to do so because the Ombudsman required it.
I would have been taking advice from the Ombudsman area in the department about what to provide.
You could have just read the email
Well,
request.
I am reading the email, and I can assure you that there would have been no motivation on my part to not provide those documents. If they were not provided, it's possibly because we'd had a conversation with the Ombudsman's office about their access to other comments and things. I mean, they were sitting in DHS at times looking at documents, etc.
I have no further questions.
Any examination, Ms Hogendorn?
Could the witness be shown DSS.5045.0001.0004? Ms Halbert, you said in your evidence you thought perhaps someone else had been involved in drafting your note.
My staff would have been involved in drafting.
Right. I just have this document. Hopefully will come up. DSS.5045.0001.0004. It's not yet in evidence. Just for the benefit of the record, it's an email from Mr Russell de Bird to you, copied to Mr Herman, slightly earlier that day at 12:20 p.m. Do we have that in hard copy? We don't. Commissioner, I'm not sure that that's available. Perhaps one way to proceed might be a short break in which I can show this to counsel assisting, and it may generate other issues. So,
All right. Can you get a couple of copies? Because obviously I'll be interested in it too. We might just take the morning break there since we started early and come back at past. Thanks.
All rise. The Commission stands adjourned until 11:15. The Royal Commission is now in session. Please be seated.
Who am I looking at? You, Mr Gregory, or Ms Hogan-Doran?
Me, Commissioner, I've been provided with the document, and in view of its contents, it's appropriate that I revisit a couple of aspects of my examination. I do that with Ms Hogan-Doran's consent. Ms Halbert, you have a copy of the document before you, and it is now on the screen. I'll tender it, Commissioner. I understand it will become Exhibit 2151A. And that won't upset the solicitors this afternoon.
2151A it is then, thank you.
Thank you.
And Commissioner, just for the benefit of council assisting, this is not redacted. There is a mobile phone later in the document.
Thank you. Ms Halbert, over the break you've had the opportunity to read through the document.
Yep.
And without going to the subsequent pages of it, can you confirm that it contains, that is the start of the email trail, is Ms McLeod's request Friday 24 February?
Sorry, that's not what I have. I just have, oh, sorry. Yes, it does.
And it might be convenient if we can just pull out, that is, the bottom half of page 0005 without reference to the, yes, if we could quickly scroll to the bottom of the second page, please. Was there? And just up a little bit. The date of this email is Friday 24 February 2017. You see that?
Yes, I do.
It is a request again from Ms McLeod.
Yes.
And it refers to a notice under Section 8 of the Ombudsman Act 1976 advising of an own motion investigation into the online compliance program. And the content is otherwise the same as the request that was contained in the earlier email. You see that?
Yes.
All right. We go then to the top of the page without the footer. If we could scroll back up, please, but not include the mobile number on the second page. The response, as it is now identified, came from Mr. Russell de Berg to you, copied to Mr. Herman, Wednesday 1 March 2017, 12:20 PM. You see that?
Yes, I do.
And can you identify who Mr. de Berg is?
He's the branch manager who had taken on responsibility for debt late 2016.
And that's the restructure that you explained earlier, which involved that area coming under your responsibility in late 2016. So he sits under you in the organisational chart. What about Mr. Herman?
He's a director who sits under Mr. de Berg.
The response or the email to you communicates that Mr. de Berg has provided you with this response for the Ombudsman due that day. Yep. And asks you if you want to pass it to Serena before it goes. So, contrary to the impression given by the earlier email, you weren't the drafter of the letter.
I think I said my staff would have drafted it.
And it was forwarded to you by Mr. de Berg, copied to Mr. Herman. And I take it from the format in which you provided it to Ms. Wilson, you cut and paste the advice into your email to Ms. Wilson.
I believe that's what I would have done.
Rather than forwarding this to her.
Well, she just didn't need that sentence.
She didn't need that information and you just copied the content.
That's right, yeah.
Yes. And that occurred according to Exhibit 1394 at 12:43 PM, so about 20 minutes later.
Probably.
Now, although it's now clear from this email that you didn't draft the advice, you obviously satisfied yourself before you sent it to Ms. Wilson, and then you received her response asking you to change the word smoothing to apportionment, and you can see from the final response to the Ombudsman that that change was incorporated.
Yes, it would have gone through the Ombudsman area of our department.
That's right.
Yeah.
Does the fact that Mr de Berg drafted the response for you to consider,
He provided it to her. I don't know who drafted it initially.
the fact that someone else drafted the advice which was conveyed through Mr de Berg, does that change your acceptance of what was represented in the email or your acceptance of responsibility for the content of it?
No.
No.
Whom did Mr de Berg or whoever drafted it, at whose direction did they do it?
As I believe I said earlier, this request came in via the Ombudsman's area of our department. They would have sent it, they possibly sent it to my coordination area, and I would have sent it to Mr de Berg.
Okay. And
Or someone would have sent it to Mr de Berg. I'm not sure who sent it to him.
I notice in your email to Ms Wilson, you said that you had told DHS that you were happy to have a teleconference with them and the Ombudsman to talk them through it.
That's right.
So you would have maintained this position and explained it. Is that right?
That's right.
Yes, thank you.
Yes. Commissioner, I've been provided with an additional document. I don't think Ms Hogan-Doran has seen it in this context, nor has the witness, but it is an exhibit. I'll take the witness through it, but in the event that you require some time to consider it, please indicate that. It is Exhibit 112, DSS.8001.0001.3405. It contains a reference to you, although you're not included in it, Ms Halbert, and I'll just ask you to read that and see whether that prompts any recollection of yours about what happened on the 28th of February 2017. Exhibit 112, DSS.8001.0001.3405. Thank you. Again, the page that we can see there is the end of an email trail. If we go back to the bottom of the previous page, or the next page rather, you can see the email Friday 24 February 2017 from Ms McLeod as the start of the sequence. All right. And then there is the inclusion of Mr de Berg a little further up. Oh, sorry, just above that.
Be shown that intervening part, just because she wasn't shown it on the other document.
Yes, certainly. If you could go to the middle of the page, Mr Avery forwards the document below to the Central Coordination Branch.
So the Central Coordination Branch is sending it to Mr de Berg's coordination person.
Right. So it came to Mr Avery from Ms McLeod. Mr Avery sends it to the coordination person, you say, for Mr de Berg.
That's right.
Right. And then if we go to the next email, which is the 27th, Mr de Berg forwards it to you, reflecting a discussion you'd had about the Ombudsman's request.
Presumably, I don't recall, but...
All right. And then if we go to the bottom of the first page of the document, the sequence right at the very bottom indicates that you reply to Janine Richards, 27 February. And copy Mr de Berg in. Important side, Janine, as discussed, I'll call you about it in the morning. You see that?
I can't see that, but anyway, I hear you, yes. I'm looking at the previous. Russell saying, here's what we were talking about.
Yes. On the screen at the top, it's...
At the top, it's, oh, sorry, is that this being sent to Janine? I can't understand what I'm looking at.
Yes, it's just your response to Janine Richards copying Mr de Berg, saying, as discussed, I'll call you about it in the morning. See that?
No. Oh, there, yes, I do, sorry, yep.
All right, yep. Thank you. And we then go to the email at the bottom of the first page from Janine Richards to Mr Grinsell Jones and copying Mr Roper. Now, would you please identify who Janine Richards is?
Sorry?
Who was Janine Richards?
She's the Chief Legal Counsel in DSS.
Chief Legal Counsel in the DSS. Mr Grinsell Jones,
He worked for Janine. He was a lawyer.
a lawyer in DSS.
Yes.
And Matthew Roper,
Or, he is a lawyer, but sometimes he worked in the corporate areas. I'm not sure. One of those two.
the Chief Legal Counsel writes to another lawyer in her area, "Hi Alan, I'm back to this morning, currently at Parliament House. Can you contact Kath for me? I spoke to her quickly last night and they're looking for advice that bridges/explains why our approach has changed from the view that legislative change was required to the view that it wasn't. Can you start by locating the relevant advices, please?" Pause there. Appreciate you haven't seen this document before, but does that prompt a recollection in your mind about a conversation you had with the Chief Legal Counsel the night before in respect of the Ombudsman's request?
Not really, but I wouldn't be surprised if I had contacted her.
And is that because it was your area of responsibility
That's right. And
at that point in time?
and we would have been going to look back at the legal advice. So.
That concludes the additional.
Thank you. Ms Hogan-Dory?
Just quickly, Ms Halbert, can I just have paragraph 29 of your statement brought up, which is exhibit.
Is it part 2 of my statement?
Your statement of 25 November 2022, it's on page 5, paragraph 29. Exhibit 2072, I'm told. It'll be shown to you. In your statement, you say, among other things, at the end of the first line, I prepared a draft response to Serena Wilson on 1 March 2017 to cover the provision of the 2014 and 2017 advices to the Ombudsman. Is it right, is it that the email that you were shown just before the break and since the break from Mr de Burgh had not been shown to you during the course of your preparation of your statement?
That one, that last one, I don't believe I've seen that in this process.
And so you hadn't had an opportunity to refresh and remind yourself of the steps that were taken prior to you communicating with Ms Wilson?
No, but if I may, in saying I prepared, I don't think I would take responsibility for the preparation, even if I hadn't drafted very few things I drafted myself. No. Not that I didn't, but saying I prepared, I presented it to Ms Wilson.
And sitting here now, do you have any recollection of the day of receiving the email from Mr de Burgh and then emailing Ms Wilson?
Not particularly. I have a general memory of our interactions with the Ombudsman's office and having to work through our central part of the department, but I don't specifically remember that day.
All right, that's all I wish to say.
All right, thank you. Mr Gregory, can Ms Halbert be excused?
She can, yes.
Thanks, Ms Halbert, you're excused.
Thank you.
Commissioner, Mr Scott will take Mr Withnell.
Thank you.
Commissioner, before Mr Withnell is called, can I hand up a list of exhibits for the balance of today? I can indicate that the documents referred to on that list, marked in red, are documents which are already exhibits. So it's the documents not marked in red which I'll seek to tender up to exhibit number 2301, which is the last exhibit before the exhibits that relate to Ms Campbell's evidence, and if it pleases, may I tender those exhibits?
Right, the documents identified in the list from 2152 to 2301 admitted as exhibits with the numbers they bear in the list. Thank you.
Thank you, Commissioner. Commissioner, I call Mark Withnell.
Mr Withnell, would you prefer to take an oath or an affirmation?
Affirmation, thank you.
Okay, could you stand and I'll just get that administered.
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr Scott.
Thank you, Commissioner. Mr Withnell, would you please tell the Commission your full name?
Yes, Mark Dennis Withnell.
And were you provided a notice to give a statement and produce documents from the Commission dated the 11th of October of this year?
Yes, I believe so.
And did you produce a statement in response to that notice dated the 14th of October 2022?
Yes.
Were you also required to were you also given another notice to give a statement and produce documents from the Commission dated the 20th of October of this year?
Yes, I believe so.
And did you produce a statement in response to that notice dated the 21st of October 2022?
Yes.
Thank you. Are your statements that we've just referred to true and correct to the best of your knowledge and belief?
Yes, to the best of my knowledge. Yep.
You are presently retired, is that right?
That's correct.
Previously, is this right, between December 2008 and August 2017, you were General Manager of Business Integrity at the Department of Human Services, which has later become known as Services Australia.
Correct.
And would this be right? In that role, you reported to Melissa Golightly.
For some of that time, yes.
I just ask you a question about your first statement, Mr. Withnell. If we could please bring up on the screen page 7. I'm just interested in the section towards the middle of that page headed Executive Minute. Do you see that?
Yes.
You see that it asks this question: provide and annex to your statement a copy of and explain and describe the circumstances of the creation of the DHS Executive Minute to the Minister for Social Services, copy to the Minister for Human Services, 12 February 2015. Do you see that?
Yes.
And you see part of your response in relation to the author of that, that you have not been in the agency since July 2017 and you do not have a copy of the Executive Minute. Do you see that?
That's correct.
And then you state in paragraph 33 that the Deputy Secretary would have been the author as she would have signed it off. Do you see that?
Yes.
And then paragraph 34, you state an assumption that the immediate recipients were the Minister for Social Services and the Minister for Human Services. Do you see that?
Yes.
Okay, if we go over the next page, we call out paragraph 35. You see that says the Minister for Social Services requested an overview of current activities related to fraud and compliance and any opportunities that could be brought forward in the budget. Do you see that?
Yes. Yep.
Okay, I'm going to call out the next section headed Any Drafts and paragraph 36. You see under that heading it says, I do not have any recollection of the drafting process for this particular executive minute.
Yes.
And is that your evidence? You do not have any recollection of the drafting process for this particular executive minute?
That was my recollection at that time.
Is it still your recollection?
I've been provided with access to some emails from that time. And there was some, not really a draft of the brief, but a collection of information that went on to form part of the brief. Yes.
Would you now accept that you were intimately involved in the drafting process for that executive minute?
I was certainly involved, yes.
Had a substantial involvement?
I guess it depends what you mean by substantial, but yes, I had input to it.
Okay. Could the witness please be shown document ID CTH.2004.0001.9608_R, which should be Exhibit 2158. Can you see that, Mr. Withnell?
Yes.
See, that's an email from you to someone called Jan Bailey and others.
Yes, that's right.
Who's Jan Bailey?
Jan Bailey was the National Manager of Payment Integrity who worked in my division.
Okay. It also is addressed to a number of other people, including Scott Britton. Do you see that?
Yes, yep.
You see the date of the email is 9 January 2015.
Yep.
You see that what's referred to as the attachments being Min Morrison brief. Do you see that?
Yes.
Morrison being Scott Morrison, the then Minister for Social Services.
That's correct.
And the email from you is, "Hi all, here's my first full draft of the draft for Min Morrison. It is highly sensitive at this time, so it is not to be shared. I'll be seeking comments on Monday, if not this afternoon." Do you see that?
Yes.
Do you recognise this email?
No. Well, I don't have a recollection of it, but I've seen it subsequently. Mm-hmm.
And having subsequently seen it, do you accept that the attachment that's being referred to in this email is an early draft of the executive minute we've just been discussing?
Yes, I don't know if it's would be characterised as an early draft of the brief, but it was certainly a gathering together of information which would go on to provide a basis for the brief.
All right, that can be taken down. Could the witness please be shown document ID CTH.2004.0001.9609, Exhibit 2159. See that, Mr. Withnell?
Not very well.
Well, if we could call, can you?
That's better. Mm-hmm.
Commissioner, could I say, we have endeavoured to get a volume of documents and hard copy for Mr Withnell, but the list only came quite late, so I understand they're still being copied. He may have some difficulty with seeing the screen.
Have you got a visual difficulty of some kind, Mr Withnell, or is it just...
Just if it's large like it is now, that's fine. I can.
Okay, thank you.
All right, you see the heading there, background, Mr. Withnell?
Yes.
You can see the words, I'll call them out in the first paragraph underneath the heading. In the welfare system, payments may be made incorrectly either as a result of fraud, when claimants deliberately claim money to which they are not entitled, customer error when claimants make mistakes, or administrative error where errors can be attributed to the legislation, policy, system design, business practices, or simply human error on the part of staff. Do you see that?
Yes.
And if we go to the third page of the document, which has the last four digits, 96111, if we call out the last few paragraphs on the page under the heading Detecting and Correcting Customer Error in Welfare Programs. You see that?
Yes, yep.
All right, and you see first paragraph states for welfare claimants the variety of changes in circumstances which they are expected to report, the complex interactions between different benefits and uncertainty about how to apply the requirement to report changes in circumstances to real life situations can make it very difficult to comply with the rules even when they want to do so. This is a key factor driving levels of customer error. Do you see that, Mr. Withnell? And then the next paragraph refers to the means-tested nature of the welfare system. See that?
Yes.
And that's, of course, a reference to how entitlements to social security are calculated. That is by reference to the means of the recipient, correct?
That's correct, yep.
And that would include their income, correct?
Correct.
And the paragraph describes the nature of confirming entitlements in this means-tested system. Do you see that?
Sorry, where was that again?
I'm paraphrasing, Mr. Withnell, but do you understand that to be a general description of challenges associated with correctly confirming entitlements during the lifetime of a claim in the context of a means-tested system?
Yes, that's correct.
Thank you. And then I'll just call out the first line of the next paragraph. One of the key responses to this problem is the use of data matching to identify inconsistencies between information customers have given to one part of government and information held on them elsewhere. Do you see that?
Yes.
And then the last paragraph on that page refers to traditionally the risk of customer error being addressed through PAYG reviews. Do you see that?
Sorry, where's that?
The last paragraph.
Oh, okay. Yep.
It talks about a high cost approach.
Yes.
See that? And the balance of that paragraph that goes over the page is being called out. You can see that.
Yes.
And just by way of explanation, this reference to PAYG review, would you agree that's a reference to the use that was then being made by the Department of Human Services of income recipients, social security recipients' income data obtained from the ATO's PAYG data? Do you understand that?
Yes, I think so. It was used as an example. A lot of the reviews were titled as a review based on the data set they originated from. So PAYG was one, DMP was another, and there were a number of others.
Yes. And PAYG data was data about a particular social security recipient's income over a period, usually about a year, correct?
Yes, I think the cycle was annual.
Yes. And a comparison would then be made between that data and declarations by recipients of their fortnightly income, correct?
Correct.
And used to identify discrepancies
That's correct.
between those two sets of data.
That's right.
And then that would then trigger an investigation.
It may, yes.
Yes, it may trigger an investigation. And of course it was...
Sorry, can I just add to that? It may trigger a review rather than an investigation. In very few cases would it lead to an investigation, which may lead to a criminal prosecution, for example, but generally it would lead to a review.
Yes.
Rather than an investigation.
And by way of review, are you referring to a process where a compliance officer would look at the file?
That's correct, yep.
Perhaps make inquiries with the customer themselves?
That's right.
And indeed request income data from the recipient's employers.
They may, yes.
And they do that typically by a formal notice under the legislation, correct?
Usually, yes.
Okay. And
I just moved that slightly. It's sort of in my eye line.
And of course, the inherent limitation on this PAYG data is that it was not directly corresponding to the fortnightly periods of employment that were being considered for these reviews.
That's correct, and that would be the case for most of the data matches. Very few of them corresponded to the fortnightly payment cycle for welfare payments.
So you, of course, understood that PAYG data by itself did not provide a safe basis for an assumption as to the actual fortnightly income of the recipient in most cases.
That's correct. And I think that's in my first statement that I make that.
As you make that point that I think the words were, you repeatedly reminded Ms. Golightly of that.
Well, I repeatedly reminded a number of people, but she would have been one of them, yes.
Did she require repeated reminding of that?
I think early on in the process, I think I may have said it a number of times, but I thought later she had understood that. But my involvement really with the particular project ended at the beginning of 2016, so I'm not sure whether that changed from that point on.
So when you,
Can you give some context for when you would have been pointing that out and in connection with what?
I think probably the easiest way to give context is to go back slightly. I think the first time we were exploring how you might use the PAYG data, particularly to try and reduce the level of debt that people were getting into, because we were unable to do a large number of reviews, probably less than 5% of the potential discrepancies. Large numbers of people were remaining non-compliant for 3 and 4 years and therefore having quite substantial debts by the time we got to them. What we've been starting to look at was how we could use any of the data at a much earlier point in the cycle of non-compliance, which would reduce the average debt size that people were getting into by means of some early intervention. We'd had some success with that.
Doing what? Saying, hey, there's this discrepancy,
Sure.
you know, make sure you report correctly, or what?
I can give you a very specific example. We had a budget measure in 2011, 2012, I think it was maybe in the MyEFO, where we used to get data, or we still did get data relating to people submitting tax declaration forms. What we used to do was wait 6 to 9 months to see if the person started declaring income. If they didn't, we would then conduct a review under the process I've described previously. That would inevitably lead to a debt potentially of 6 to 9 months duration, which the person would then have to repay. What we did was decide that we could use the data because we got it every week. Why didn't we use it every week? And we started doing what we would call a light touch compliance intervention. So we actually rang people to advise them that we'd received information that they may have just got a job, have a general conversation with them and offer assistance to help them get their income declarations right from the start. What we found with that process, we averted or prevented debt to the value of over 100 million a year. And what we also saw was a significant reduction, I think something in the order of 100,000 matches within the PAYG data. So not only had we prevented people getting into debt, so to save them that hardship, but also we'd reduced some of the matches, which meant that people were remaining compliant after we'd assisted them to begin with. So that's probably the best example. I'm sorry, I've lost my thread now of your question.
No.
You were explaining in the first instance how PAYG data was being used, because I'd asked you the context in which averaging and its inappropriateness to gauge debt came up.
Yep. So the PAYG data match was probably the biggest in terms of the number of matches that it identified. One of the ideas, or really we're at a very much an exploratory stage, and there were a number of projects alive in the Commonwealth, the digitisation agenda, something called single touch payroll with the ATO as deregulation, and there was also an infrastructure transformation program within DHS which was looking at how you move a lot more things online. So in response to that, we began to think, are there opportunities for how we might take advantage of that? Very early on, we looked at would it be possible prospectively, and would it require any changes to legislation or policy to be able to provide information, say, from the PAYG data, which we might get in a more regular cycle from single touch payroll, in a way that gave people the opportunity to either confirm the information that we presented or to alter it and amend it to make sure that their entitlements or their payments were correct at the earliest possible opportunity. So that was very much looking at a prospective model. There were difficulties, I think, that would come in terms of if you could then move that to retrospective. And I'm happy to go on if that's part of the question you were asking. I'm kind of lost my thread a little bit.
Well, again, back to the thread, which was you were having to tell people averaging wasn't a means of debt raising, and you've suggested to us some things that the PAYG data could properly be used for.
Yep.
But in what context were you saying you can't use it as which I understood you to say that you couldn't properly use it as a means to work out debts?
Sorry, Commissioner, I'm just struggling to hear you.
I understood you to say that you had told people that averaging wasn't an appropriate means of raising debt.
Yes.
And I wanted to know in what context were you having to tell them that?
Okay. So once we were asked to come up with ideas for the brief that we referred to earlier for Minister Morrison, one of the suggestions, and it was a very early suggestion that you've referred to on the February the 9th paper, was whether we could look at the PAYG in retrospect. I felt a little bit uncomfortable with it, but we put it in with the view that we would have a number of options that we could then refine. I think there were maybe 12 options in that initial paper for different activities. The further we went in, the more it became apparent to me that, and this either was internal discussions, my own thinking, or discussions with DSS, I can't be sure which, over a period of weeks, that it was not possible to look at some of the similar things we've been looking for prospectively, to look at those retrospectively. One of the key issues would be the date of effect. The date of effect, looking prospectively, would mean changing, say, legislation or the way in which income was treated, which you could do going forward, providing, of course, you gave people information about that and lead in time. Looking retrospectively, that would become problematic because you would need a retrospective date of effect. So if you took the date of effect back, for example, in this case, potentially 3 or 4 years, it would have the effect of having to reassess all welfare claims within that period. And that clearly wasn't going to be an option. And I think there were some other aspects in relation to retrospective legislation that I don't recall details of. But it was clear that looking at changing legislation for a retrospective approach was simply not going to happen and was probably counterproductive anyway. So that was forming part of my view. At that point, what we started to look at was, is there still a way to use the data using prompts but not doing or using it to apply to the customer's record or the recipient's record? So how do you provide the information in a form that may prompt individuals to self-correct or confirm information, rather than using it as a means to deliver a particular output, if you like, or an application to the customer record. So in that context, as we shifted from using things like income averaging as a possibility, I, over the next period of time, found myself having to shift people's thinking from that to using, if you like, effective communication to get people to self-correct or confirm the information we were provided, and that you couldn't use the data from PAYG as a basis to apply to the record, therefore amending the person's rate and potentially creating a debt. So it was in that context that those discussions were starting to occur.
And you always had that view?
I don't know, I can't recall what my earlier view might have been in the early stages when we were looking prospectively. I knew it would be difficult because certainly the assessment of income and how that's managed is quite complex and quite fundamental, and so that's why it was an exploratory thing at that point. Once we started to look retrospective and I got time to think through some of the options, it became evident, I think, at that point that we couldn't go to that stage and that would be counterproductive to look at the legislative change.
Mr. Scott?
Thank you, Commissioner. If we could go to the page of this document which has the last 4 digits, 9616. And if we could call out the section headed correct down to just above case cleansing. Now, might I take it that we've discussed enough about this document that you're agreeing that this was the attachment to the email that I showed you just before?
Yes.
And I don't think you quite agreed that it was an early draft of the brief to Mr. Morrison, but it was a collection of the information that formed the basis of that brief.
It was information that we'd gathered in, I think, 2 to 3 days to meet what we've been asked to do. And my recollection is that Ms. Golightly had then been tasked to take on responsibility for my division and this project, and she'd asked for basically what we had to start the ball rolling in terms of the brief.
So is that a reference to Ms. Golightly informing you that she'd been instructed to put together some proposals for the minister?
No, not quite. Memory, the secretary had advised me when she'd asked us to pull things together that she was making a shuffle of responsibilities within the agency, and that Ms. Golightly would become the deputy responsible for my division and this project, and that she would take carriage of that. I think there may have been a few days between me knowing that and Ms. Golightly starting, and my recollection is that as she knew she was coming into that job, she'd asked for what we had at that point as the basis for starting the brief to Minister Morrison.
Okay. And am I right that the section of this document that's been called out is one of the proposals that you pulled together for that purpose?
It was one of the ideas, yes.
And this is, you'll see it's headed PAYG cleanup. Do you see that?
Yes.
Says that the proposal will introduce a digital approach to interventions with customers with historical information from the ATO.
That's right.
See that? And would we be right in, of course, taking the position that the information from the ATO is the PAYG data we've been discussing?
Yes, I would say it was.
All right. And then it proposes interventions being undertaken in a digital environment.
Yes.
Customer will be presented via their online account with the information obtained from the ATO. See that?
Yes.
And an assessment of their correct welfare entitlement based on this information. Do you see that? The assessment will use an income smoothing methodology to apportion the customer's income over the time of employment. See that?
Yes.
And the customer will have an opportunity to update information prior to it being applied to their Centrelink record.
Yep.
And you can see that the second last paragraph says the proposal will provide for a measure to undertake 866,857 interventions for customers at risk of undeclared or underdeclared income. Do you see that?
Yes.
And it says it is anticipated that this would result in an estimated $1.2 billion gross savings and debt due to returned outlays. Do you see that? And then the last line is there would need to be a change in departmental policy in relation to the application of income smoothing to assess a customer's income from employment. Do you see that?
Correct.
Now, this is in effect an early articulation of what is now known as the Robodebt scheme.
It's a very early articulation, as I described earlier. It was the transition from looking at the using that prospectively to now whether it could be a retrospective approach, which then changed over the next 3 to 4 weeks.
Yes. And I suggest that even in this early form, a fundamental aspect of the proposal was the use of an income smoothing methodology to apportion a customer's income over the time of their employment. Do you see that? Agree with that, I should say?
Yes, I can see that.
Thank you.
Sorry, did you have a question there other than can I see it? I just missed a bit of what you said, that's all. Sorry.
Sorry, I misdescribed my question and talked over the top of you. I was asking you whether you agreed that even at this early stage, a fundamental aspect of the proposal was the use of an income smoothing methodology to apportion the customer's income over the time of their employment.
I think what I would say is that only at this early stage, I think the notion of income smoothing in the subsequent ways in which it was described and I understood it had dropped off as a way of certainly being applied to the record. There were discussions about whether there were different ways of presenting information that may prompt people to self-correct, but they were much later discussions when we were looking at the communication aspects. But certainly at this early stage, as I described earlier, when we were looking prospectively, the ways of getting people to reconcile information simply and easily were being explored, and that was one of those that was being explored. It came into this draft simply because I think we had maybe 2 days to pull this together and there was just a general gathering of information which may have been left over from earlier bits of work that we'd done. And as we moved to correct those or to refine those over time, some of those things change. In fact, a number of those particular ideas changed quite significantly.
Well, isn't an income smoothing methodology simply a calculation of someone's income by averaging their total amount of income over a period for each individual fortnight under consideration?
There are a number of definitions for income smoothing. I think income averaging describes what you're talking about, and income smoothing may have been used interchanged with income averaging, was providing an average, it refers to providing an average income for a defined period according to each fortnight, so it could be apportioned to determine the correct rate. That's what income averaging talks about. Income smoothing is similar, but it also refers to We also used it to refer to actions undertaken by a recipient who were able to smooth their own income to meet their needs by moving in and out of debt. It emerged out of a research project we did 2 or 3 years earlier, where we identified multiple debtors and talked to them about what information would assist them. What was clear was many of them used going in and out of debt as a means to maintain a stable level of income to meet their needs.
But in this,
That was referred to as income smoothing.
in this context, income smoothing is being used as another way of expressing income averaging, isn't it?
It's used as that sentence says, using it to apportion the customer's income over a period of employment.
For the purpose of calculating their entitlements.
No, it doesn't say that, does it?
Well, perhaps you might be assisted by reading the last line. There would need to be a change in departmental policy in relation to the application of income smoothing to assess a customer's income from employment. Do you see that?
Yes.
And also in that earlier paragraph, it says an assessment of their correct welfare entitlement. Based on this information, the assessment will use an income smoothing methodology. So it does seem to be about assessment of entitlement.
An assessment's different from an application. In terms of assessment, it may well be, and I can't tell you what was in my mind or the mind of people who provided this to me at the time, but the assessment may well be simply saying to the recipient that, well, there are a number of different ways it could actually play out, and it was really about providing information. The key is whether that information is then applied to the record, in which case it triggers the reassessment of the entitlement.
Well, if you're assessing entitlement based on smoothing methodology, that's exactly what you're doing, isn't it?
No, there's one more step. You can make an assessment I could provide to an individual based on the information we've got. This is an indicative assessment of your entitlement based on that, but you have to then act on that to apply it to the record, which then triggers that reassessment and entitlement and applies it to the record and therefore may create a debt. So there's one more step in that process.
Well, the only extra step is just to raise the debt, isn't it?
Sorry, I didn't
The only extra step is to raise the debt once you've assessed entitlement on this basis.
was to apply it to the record, which would then trigger a reassessment of their entitlement, and that would indicate whether or not there was a debt. Then you have to determine the debt, and then you would raise the debt. That would be the steps.
Based on the income smoothing.
Based on whether the individual, as it says there, whether they had updated the information, or they'd corrected the information, or they'd accepted the information.
And if they hadn't, then the income smoothing would be used to calculate their entitlement, correct?
I'm not sure, where does it say that?
Well, how are you going to get this 1.2 billion in savings and debt on returned outlays unless you did act on non-responses?
At this point in time, I don't know that we'd had that level of discussion about how the mechanics of that might work. There was obviously some recognition that some people wouldn't respond for a whole range of reasons, but the details of how you might respond to that were still to be worked out.
Well, passage in the second last paragraph says it is anticipated that this would result in an estimated $1.2 billion in gross savings.
That was based on the data we had, which we would then provide to DSS, who calculate the savings.
And the data you had was, is this right? The amount of discrepancies between the ATOPA-YG data and what had been declared to Centrelink.
The 866,857 interventions would be the number of cases, if you like, where there was a discrepancy between those two amounts, yes.
And is that year by year? In other words,
I'd
have you
say-
added up some years to come to that conclusion?
I would say that's cumulative.
Yes. So you might have one customer who in 4 successive years fails to, or has a discrepancy, and that'll be 4 interventions, will it?
That's correct. Yeah.
Thank you.
And by discrepancy, you're referring to the situation where there is simply a difference between the ATO PAYG data and what had been declared to Centrelink.
That's correct. There were some tolerances built in to the data match, so it had to exceed a certain amount. I don't know what those amounts were at this time.
But among those discrepancies, you would have known that it would be likely that calculations of entitlement based purely on ATO PAYG data would be inaccurate, wouldn't it?
What I would say is that there are probably 2 scenarios where it's more likely to be inaccurate, which would be where the individual had inconsistent earnings reported. There was a higher likelihood that at some point that had become a problem. And also instances where the employer, in sending in the PAYG information, had used the default of 12 months employment where the individual hadn't been employed for 12 months, so there would be a discrepancy in terms of the period of employment. In those 2 instances, the likelihood of inaccuracy is higher because of the nature of them. In instances where an individual had consistent earnings that didn't vary from fortnight to fortnight, it's less likely.
As you've just agreed with me earlier, there would be far less cases than the cases where the customer's income varied from fortnight to fortnight.
Sorry, I'm not clear what you're saying there.
I thought you agreed with me earlier that a substantial majority of customers' incomes would vary from fortnight to fortnight.
I'm not sure that I said that, but I'm happy for someone to read that back and see if that's what I said.
Would you agree with that proposition then?
I don't know.
So you don't know one way or the other in any event?
Well, there are a lot of people on welfare payments. I don't have any information that allows me to judge how many of those people have inconsistent levels of earnings or anything of that order. I'm not sure quite what you're asking, Council, sorry.
You'd know that, for example, a significant portion of recipients of Social Security would be students.
Yes.
Who would often be working casual hours.
Yes.
And would therefore have variable income. You'd know that.
Yes, yep, likely.
You'd know, for example, that with respect to seasonal workers, their incomes would likely vary.
Correct.
And you might find seasonal workers on Social Security, correct?
Correct.
And that might, for example, be older people who've gone into retirement and are travelling around the country, working fruit picking and the like.
Yes.
Or people might just work 2 jobs in a year at different rates and then have no employment at all in another period.
And that's why I made that point that there are those 2 instances where it's more likely that using the PAYG data would lead to an incorrect assessment.
And this description of anticipated $1.2 billion of gross savings made no account of that.
It did. I think in the assumptions we allowed for a level of no debt. I can't recall what that assumption was at that time. I think it was lower as it went back in the years, but I can't be 100% certain on the specific details. But the assumptions did allow for that instance. In the PAYG reviews that we'd done traditionally, my recollection is that 95% or thereabouts of the reviews actually returned a debt. We felt that was highly improbable with the number and given the scale. and so it was significantly reduced. I can't remember to what level it was reduced to based on that assumption that you've just outlined.
Can you tell us who performed the calculation?
The assumptions would have been generated from the data matching team based on what they were seeing within the data. Those assumptions, so for example, there was an assumption that potentially, let's say 60% may return a debt. That then is provided to DSS, who do the calculation in relation to the savings based on those assumptions.
When you say the data matching team, who are you referring to?
They were a team within Mr. Britton's area who performed all of those data matching analysis, which then led to the reviews that his branch undertook.
All right. Now, just coming back to the words in the last sentence in that passage called out, you can see the words are, there would need to be a change in departmental policy in relation to the application of income smoothing to assess a customer's income from employment. Do you see that?
Yes. Mm-hmm.
And those words reflect the fact that at that time it was contrary to policy to assess a customer's income from employment using income smoothing.
As a general rule, yes, there was still, if my recollection's correct, the ability to use income smoothing in exceptional cases.
Another way of describing that would be as a last resort.
Potentially as a last resort, yes.
Can you give an example?
Sorry?
Can you give an example of the exceptional case in which income?
Where perhaps an employer had gone out of business and information wasn't available, the recipient may not have the information available to them, and so there were discussions then around what might be a reasonable way of overcoming those obstacles. One of which, if the person had relatively consistent income or over the period of time, applying a smoothing methodology may have been acceptable to both the organisation and the individual.
So this would be a sort of agreed position between customer and
that's right.
DHS that
Correct.
I haven't got the pay slips for this bit, but that's what I used to earn.
Yep, that's correct.
Okay, you weren't really in that event in relying on income averaging so much as the customer's information that was a relatively
So
accurate.
agreeing that averaging it was the best way to go.
All right.
That document can be taken down. Can the witness please be shown document CTH dot 3 008 dot 0007 dot 8243 underscore R, exhibit 2160. You see that document, Mr. Withnell?
Yes.
You agree that's an email from someone called Melissa Ryan?
Yes.
Who's Melissa Ryan?
Melissa Ryan was the general manager. I'm just trying to think of what the title was. Employment, I think, may have been her title, but it was really looking at issues around New Start and other employment type payments.
Where did she fit in the reporting structure in relation to you in the department?
Both she and, I think at that time, both she and I reported to Ms Golightly.
Okay. And of course, this email is addressed to Ms Golightly and yourself. See that?
Yep.
There's some others, but their names are redacted.
Mm-hmm.
And the date is the 20th of January 2015. Do you see that?
Yes.
And got an attachment called Appendix 1. See that?
Yes.
It says, Melissa, Mark, here's the latest version of the compliance brief. See that?
Yes.
And it says, I've talked with Kath Halbert and have sent her version for feedback. Kath mentioned that Serena and Finn were currently meeting with Minister Morrison, so there may be some further developments. Do you see that?
Yes.
Okay. May the witness please be shown doc ID CTH.30008.0007.8244, exhibit 2161. Do you see that purports to be, and we'll just go to the top of the page, Department of Human Services, draft Department of Human Services executive minute,
Yes. Mm-hmm.
addressed to the Minister for Social Services for action. And just call out the first two recommendations towards the top. First is that you note the current arrangements to maintain the integrity of welfare payment outlays. See that?
Yes. Yep.
And then the second recommendation is that the Minister agree to the development of a package of new policy proposals to strengthen the integrity of welfare payments. Okay. And you, of course, know what a new policy proposal is.
Yes.
And would this be right? A new policy proposal is a documented proposal that's presented to initially the Expenditure Review Committee of Cabinet.
Correct.
And then Cabinet itself
I believe so.
to approve spending for a particular measure.
Correct.
For the budget.
That's right.
Okay. And if we just take that call out down, we call out the paragraph 2 at the bottom of the page, which goes over the next page. Can you see that clearly, Mr. Withnell?
Yes. Yep.
See that this talks about welfare payments. The welfare system payments may be made incorrectly for a number of reasons. You see that?
Yes.
And then the next paragraph on the next page, first sentence, identifies fraud and error as significant problems with a potential cost of $3.6 billion a year. See that?
Correct.
Okay. And then if we go to the next page, call out paragraph 9. There's a statement there is a number of options outlined in attachment B, identified to strengthen the integrity of the welfare system. See that?
Mm-hmm.
And then if we go to the page of the document with the last 4 digits, 8255.
Sorry, can we just go back to that previous one? I didn't have a chance to read it properly.
Sorry.
Okay, thank you.
So if we go,
Commissioner, can I provide the witness with my hard copy? It may be of assistance that he actually has the full
All right, thank you.
document.
Thank you. Sorry, Council. Yep. where
Content
would
for
you
me
like
to
me
take
to
you
go
to the next part of the document, Mr. Withnell?
Sorry?
You content for me to take you to the next part of the document that I want to
Yep,
take?
sure.
Thank you. So it's attachment B, which the top right-hand corner, the doc ID numbering has as the last four digits 8255.
Yes.
And just to satisfy yourself, could you just read, not reading it aloud, but just to yourself, the passage headed Potential Priority New Proposals to the bottom of the page?
Yes.
Now you'd recognise these words as a further development of the part of the document I showed you earlier, which you described as, I think, a collection of ideas.
There's some refinement, but there's it's relatively similar. Mhm.
Yes, a further development. And you can see that the proposal will introduce a digital approach to interventions with customers when historical information from the ATO indicates the customer may have incorrectly declared their income from employment. Do you see that? Paragraph 1A.
Yes, yeah.
And then the next paragraph talks again about interventions in a digital environment. See that?
Yes.
And the customer will be presented via their online account with the information obtained from the ATO and assessment of their correct welfare entitlement. To see that?
Correct.
And then the next passage, the assessment will use an income smoothing methodology to apportion the customer's income over the time of employment, rather than the current cumbersome process whereby the department has to determine and apply income on a fortnightly basis. Do you see that?
Yes.
And then it says the customer will have an opportunity to update the information prior to it being applied to their Centrelink record.
Correct.
Okay. And then I just will identify the next subparagraph, C. The proposal removes the need for the department to be dependent on customer and business information as the default and instead relies on the use of data already collected by the ATO as the default, unless customers want to and are able to provide information that varies the outcome. Do you see that?
I do. Yep.
And I suggest to you that those words identified as a part of this proposal a fundamental change in how income was assessed for the purpose of calculating entitlements by proposing that ATO data would be used as the default.
Sorry, what was your proposition there?
This aspect of the proposal proposed a fundamental change to how income was assessed for the purpose of calculating social security entitlements by using ATO data as the default.
This was still a very early phase in terms of developing the proposal. So I understand this had gone to DSS, which is reflective of the email you showed earlier, for their feedback. To my recollection, they provided some feedback in relation to this, and the proposal then changed quite significantly as we moved towards the brief.
I don't think you answered the question at all, Mr. Withnell, which was whether this proposed a fundamental change to the way that entitlements were assessed.
This is, yes, it is,
Okay.
as a proposal at that point.
And the fundamental change was that by using ATO data as the default, that was in contradistinction to using income smoothing in exceptional circumstances, to use the words you used just earlier with me.
Sorry, I'm not clear on your question, Council, sorry.
The fundamental nature of the change was in using ATO data as a default was because it was to use that data in income smoothing as a default rather than in exceptional circumstances.
That's what was put at this point in time.
And that was a fundamental change.
It would have been, if that was, if that had gone ahead, that would have been a fundamental change, yes.
Well, I suggest to you that that was always the proposal and it never changed.
Well, that's not the case.
How did it change?
In the brief that went to ministers, I think the whole notion of income smoothing was removed, and it was much more clear about just providing information to the individual, and that they would be asked to correct or confirm that information before anything was done with it. In the MPPs much later, it was quite explicit, both in that and saying that there would be no change to the way in which income was treated or managed. I refer to both of those in the additional letter I provided last week when I'd seen those documents and seen how the flow of thinking went from late 2014 through to March 2015 with the MPPs.
But the words Mr. Withnell used in this passage explicitly acknowledges that customers are given the opportunity to provide information, doesn't it?
Sorry, they explicitly...
Acknowledges that under the proposal, customers would be given the opportunity to provide information.
Correct. That's always been the case.
That was always part of the proposal.
Yes.
And it was always part of the proposal that if they didn't provide information, their entitlements to social security would be assessed using income smoothing.
That's not my view.
So what was your understanding as to what was to occur by way of assessment of a customer's entitlement if they did not provide information?
As I said earlier, this is still very early stages in trying to develop the proposal. Some of these, as I said in my first statement, when we first put them forward, were at different levels of maturity and required a degree of working through them. This is still very early days. We hadn't been in a position where we'd been asked to bring anything forward for the budget in the previous few months. Normally that would happen in October, November, December. This came out of the blue in January. We had no firm or worked up proposals. We had a number of ideas that we'd been exploring, which we then put down with a view that we would, over time, over the next 2 to 3 weeks, as time permitted, refine each of those proposals, and hopefully, we were hoping a number of them would fall away and that we'll be left with, a handful, if that, that were ones that will be taken forward to the Minister. Unfortunately, that editing process still left quite a number of proposals, and we were trying to juggle developing what effectively I think was 10 ideas in a very short time frame across multiple sorts of areas. Some of them, evolved quickly, some of them evolved slowly. PAYG cleanup evolved slowly at the early stages, as I explained earlier, evolved out of quite a different exploratory process. As we started to think through how you might work on this retrospectively, things changed over time. So income smoothing, in my recollection, and I'm happy to be shown elsewhere, by the time we get to the brief to ministers, reference to income smoothing has disappeared. And I think it's quite clear that the focus is on the individual providing either confirmation or correction to the information available. When we get to the MPP, we're even more explicit, and I can point you to the paragraph if you'd like me to, that it doesn't change, the proposal as it stood then, doesn't change the way in which income is treated or assessed.
So when you say that the brief to the minister, do you mean to Minister Morrison?
Yes, sorry, Minister Morrison and Minister Payne, I think, was copied into that brief. Yeah.
You say that that didn't contain any notion of income smoothing?
I don't believe so, but happy to be corrected, but I'm pretty sure it doesn't mention income smoothing. If you want to have me to find the document or if you'd like to look at it, I'm not sure. But
We'll come to that shortly, Mr. Withnell, but I'm just trying to understand your evidence. Income smoothing, as I thought we agreed, in this context is referring to the use of income averaging to assess a recipient's entitlements, correct?
Correct.
And that was clearly a part of this proposal at this stage.
At this early stage, yes.
And also, as you can see from the passage that's been called out, the proposal specifically comprehended that unless customers want to and are able to provide information that varies the outcome, that methodology would be used.
Yes, I'm not sure where that variation comes from. It's not in any of the documents I've seen.
And what I'm putting to you, Mr. Withnell, that what I just described in this proposal was always, in all iterations of it subsequently, a fundamental aspect of the proposal.
Which aspect are you talking about, sorry?
The use of income averaging to calculate to assess social security entitlements if the customer does not provide information that varies the outcome.
Not that I'm aware. That's certainly not my view.
All right. The witness please be shown CTH.2004.0002.0332_R Exhibit 2066. Just call out the email at the bottom of that page.
Yes.
See, that's an email from Ms. Halbert,
Yes.
addressed to Melissa Ryan and yourself.
Yep.
The 20th of January 2015.
Yes.
And it says, Melissa, as discussed, here are our comments on the compliance part of the brief. We feel particularly strongly about the clean-up PAYG measure. You'll see the comments. You see that? And then we go up to the next email in the chain. Should be an email from Melissa Ryan to I think we're missing part of the email. Oh, I see. Seems to be a further email from Melissa Ryan to Melissa Ryan forwarding the below email. But if we go the next one up, that's Melissa Ryan to yourself and Ms. Golightly, dated the 20th of January 2015. Do you see that?
Yes.
And it says, Mark, Melissa, DSS have provided comments on the compliance parts of the brief. They have marked up comments in text boxes. The key area of concern is the clean-up PAYG measure. Do you see that?
Correct.
Okay. And then we go to the next email in the chain at the top. It purports to be from yourself, to Mark Brown, Scott Britton and some others whose names are redacted. See that?
Yes.
And it says attachments DSS comments on DHS welfare integrity options, the 21st of January 2015.
Yes.
See? And it says, for your consideration, then in capitals, the words are do not forward.
Yep.
Can you explain those words, do not forward, Mr. Withnell?
Because at that stage, my understanding was that it was kept relatively confidential. Mr. Brown and Mr. Britton both had responsibility for different measures within the new policy proposal. And I was getting them to have a look rather than forwarding on to other members of their staff to have a look at the comments from DSS so that we could discuss them.
Why capitalise the words do not forward?
So that they would see it.
Why was it so important?
Well, at that point in time, I think it was important just for the national managers and I to have a discussion about what those comments were so we could determine a way forward.
Right. Can the witness please be shown document CTH.2004.002.033. Exhibit 2067.
Can I provide a hard copy for the witness? It's a longer
Thanks,
document.
Ms. Hogan, Director.
You have a copy of that document there, Mr. Withnell?
Yes. Yeah.
See, it's headed Proposed Changes to Strengthen the Integrity of the Welfare System.
Yes.
Attachment B. See that?
Yes.
You'd recognise the reference to Attachment B to be Attachment B to the draft executive minute that we've been discussing.
Yes.
Go to scroll down and call out general comments section. See the first bullet point, DSS acknowledged that each proposal only sets out the broad scope for each proposal. You see that, Mr. Withnell?
Yes. Yep.
Do you see the next bullet point? Most proposals will require legislative change. In some cases, there are fundamental impacts on social security policy and law.
Yes.
And then the third last bullet point, it could be expected that some proposals will come under significant scrutiny as not being consistent with the overall beneficial nature of social security law and for the imposition of what may be considered to be retrospective legislative arrangements. You see that?
Yes.
Okay, if we go over the next page, we call out the heading at the top. See there, that's the section that we've been discussing from the draft attachment B.
Yep.
Potential priority new policy proposals, reference to the PAYG cleanup.
Yes.
And in paragraph 1B, the reference to the assessment using an income smoothing methodology
Yes.
to apportion the customer's income over the time of employment, and the reference to the current cumbersome process. You see that?
Yes. Yep.
And then if we call out the box at the bottom of the page, first bullet point, see the words, the proposal fundamentally changes the assessment of income within the social security system and is not supported by current policy or legislation. You see that?
Yes.
Next bullet point, DSS Public Law Branch confirms that the suggested calculation method does not accord with social security legislation, which specifies that employment income is assessed fortnightly. You see that, Mr. Withnell?
Yes. Yep.
And you'd accept, wouldn't you, that the reference to this being confirmation by DSS Public Law Branch is a reference to DSS legal advice?
I would imagine so, yes.
Next bullet point says the legislation is framed to support the policy rationale for assessing employment income on a fortnightly basis, which ensures that income support payments are made when the recipient is most in need. This proposal would introduce an arrangement that runs counter to that rationale. See that?
Yes.
And then fourth bullet point, proposal would introduce dual mechanisms for the calculation of debt, i.e. in some instance on a fortnightly basis and on others on an annual basis. Do you see that?
Yes, yep.
And then if we call out the final bullet point, which goes over the page,
Yes.
smoothing income on an annual basis is not consistent with the policy directions DSS wishes to pursue for all payments, including family assistance, under welfare reform, taking the opportunity provided by the ATO single touch payroll development to implement this. This should government agree. Do you see that?
Yes.
Can somebody see what that noise is and see if you can do something about it? Thanks.
Next bullet point down refers to a High Court decision about retrospective legislative changes. You see that?
Yes.
Next down, reference to issues concerning the potential for recipients not being able to effectively exercise their review rights to ensure they are not being disadvantaged.
Yes.
And the example given below that is constraining review rights by suggesting that debts could only be challenged if the income support recipient provides fortnightly earnings data, shifts the responsibility entirely to the recipient to ensure their debt was correctly calculated, and does not take into account administrative error. And then the next bullet point talks about annual data matching by its nature lead to the raising of large debts, which are more difficult to recover. Do you see that?
Yes.
And then the final bullet point refers to the prospect of the single touch payroll initiative that's coming in a few years, as at the date of this document, rendering this whole proposal unnecessary.
At this stage, I don't think there was a time frame for single touch payroll to come in, but it was, I think at that point, maybe 2018 or 2019, I'm not sure.
The point being made in the bullet point is that this whole initiative would be unnecessary once single touch payroll was introduced.
Correct, we understood that. Which is, as I said earlier, the earlier exploratory work that was done in 2014 was with a view to how you then merge into single touch payroll as it's rolled out, which would provide that opportunity over time to get the information on a more regular basis. So that's why I was looking prospectively.
Now, you'd agree, wouldn't you, that this was raising clear, I'll withdraw that, this was clearly expressing the DSS position that the use of income smoothing to assess a customer's social security entitlements was both unlawful and contrary to policy.
Correct.
And it was emphatically stating it.
Correct.
And it was doing so where the proposal explicitly contemplated that the assessment using that methodology would happen after attempts were made to engage the customer.
Sorry, could you just say that again?
The proposal explicitly contemplated that this methodology would be used after attempts were made to engage the customer.
I'm not sure that that's accurate. Can you point me to that part where it says that?
Paragraph 1B.
So did you say paragraph B?
Yes.
And where does it say what you just said, sorry?
Well, it says interventions will be undertaken in a digital environment the customer will be presented via their online account with the information obtained from the ATO.
Yes.
That's clearly a reference to an attempt to engage the customer, isn't it?
Yes, yeah.
And so this proposal explicitly contemplated the use of income smoothing to assess entitlements after attempts were made to engage the customer.
Sorry, where does it say that?
It says the customer will be presented with information
Yes.
and an assessment of their entitlement based on it using an income smoothing methodology to apportion the customer's income.
And the customer will have an opportunity to update the information prior to, prior to it being applied.
Yes.
So I'm sorry, I'm not sure what your point is, Council.
My point is that this proposal explicitly involved income smoothing to calculate social security entitlements after attempts to engage with the customer.
I'm still not clear where it says that, sorry. I'm not sure where it says it will be used after attempts.
Well, it says that the opportunity to update is prior to the smoothing. So it seems to follow that the smoothing happens after the customer's given the opportunity to provide information.
Sorry, I'm not clear on that.
The order of events as presented in this paragraph is the customer gets the information from the ATO. The customer has an opportunity to update the information prior to an income smoothing methodology being applied to their record. Is that not right?
I read that last sentence to be the customer will have an opportunity to update the information. The information may well be the corrected information provided by the recipient.
Mm-hmm.
So information will be provided. There may be an assessment of correct entitlements using the ATO data, but that's just there as an assessment which is indicative for the recipient. Customer can update the information, or I guess an alternative would be that they could accept the information. But the point I think is key is that it's prior to it being applied to their Centrelink record. And it relates back to what I said before, that there are two steps in the process. You can make an assessment of entitlement, but until it's applied, it doesn't become effective.
But the point of this proposal is that if the customer does not update their information, it would be applied.
But what I'm asking you is, where does it say that? Because I can't see that proposition.
How on earth could the savings proposed in this proposal be realised if
Can I just understand what you're saying,
Sure.
Mr. Withnell? You're saying the assessment will use an income smoothing methodology to apportion income, but nothing will ever happen thereafter. It'll just do the assessment and it won't be used.
Possible, yes. It was there, in my view, as an indicative assessment. If the information that had been provided was to be applied, here's what the impact would be, which is why it's important for a person to go on and correct the information.
And if they don't?
Well, we don't refer to that there. I'm not sure what the thinking was at that time in relation to that.
But you were involved, I suggest, intimately in the development of this proposal, and you weren't you?
I was involved in all of these proposals, yes.
And you well knew what was to happen if the customer does not go online and update their information.
Well, no, that's not correct. As I said earlier, these were very much in the formative stage. And so not all of the details had been fine-tuned. At this early point, we were providing an early draft to DSS so they could provide advice to us as to what may or may not be valuable. Their advice is useful and I think leads to some of the changes that then occur. And certainly, as I mentioned earlier, the whole notion of retrospective legislation, whether I'd come to that realisation myself or I gained it from this at the time, I don't know. But there are other elements of this which raise concerns which were then taken account of, in my view.
I suggest to you that the passages in the comments section that I just took to you, which you would recognise as being the comments provided by DSS, are comments about the proposal to use income smoothing to assess entitlements when the customer does not update their information.
Again, that's where I have trouble. I'm not sure where it says that particular thing. As I say, this was still early in refining the proposal. Yes, I agree, there was talk about providing an assessment based on an information smoothing methodology, but it also is clear that the customer has the opportunity to update prior to it being applied. There's no reference to what would happen if the customer didn't, because at that stage I'm not clear in this proposal at this early point that those processes have been thoroughly worked through. The information then provided by DSS helps to inform some of the later iterations of the proposal before it goes to the Expenditure Review Committee.
I suggest to you that it's obvious that the DSS comments critical of this proposal was on the impact that it would have on social security entitlements of social security recipients. You agree with that?
Yes.
And this proposal could only have that impact if income smoothing was to be used to calculate a social security recipient's entitlements.
Sorry, can you just repeat that back to me?
The proposal could only have an impact on a social security recipient's entitlements if the income smoothing methodology described was in fact used to calculate their entitlements.
If I understand you correctly, you seem to be proposing there that the only way an impact could be made on a recipient's entitlement was through income smoothing. Is that correct?
Well, that's the only impact that's contemplated by the comments in the DSS comments in the box that we've just discussed.
And if the individual goes in and corrects the information, and that's then applied, that's not using income smoothing. So I'm just not clear what it is you're suggesting, Council, I'm sorry.
What did you think DSS were worried about there?
I think there are a number of things. One was the fundamentals around the assessment of income on a fortnightly basis.
Yes, and averaging was contrary to that.
And smoothing income was not consistent with the directions they wanted to pursue. I think the application of it retrospectively.
Okay, but they were worried about
So there are a number of issues, yes.
Can I just get your position, Mr. Withnell? Is it that after an early notion that averaging would be involved in this new scheme, which ultimately became Robodebt, that was abandoned? There was nothing about it in what went to Mr. Morrison or Mr. Payne or Miss Payne. It wasn't contemplated at that stage. It wasn't contemplated with the new policy proposal. Is that it?
That's, to the best of my recollection, that's how it evolved.
And when did it first, or did it ever, dawn on you that it might have been used?
I don't know that it ever dawned on me. My responsibility ended at the beginning of 2016, so I didn't see final business process design or system design or any of the testing which may have flagged some of those issues. In fact, to this day, I've only seen a very small part of the system, so I don't know how it operates and how it actually was finally implemented.
So has it ever come to your attention that averaging was used?
Not that I'm aware of. It may have come up through third or fourth hand, but I was never involved in any review of the system, which would enable me to have seen that, which might have prompted me to respond.
All right. Is that a convenient time, Mr. Scott? But I was going to suggest we might come back early
Yes, Commissioner.
in view of Ms Campbell waiting, perhaps 2 o'clock.
Thank you, Commissioner.
Does that suit you all right, Ms Hogan-Joy?
Yes,
Thank
Commissioner.
you. We'll adjourn till 2 o'clock.
All rise. The Commission stands adjourned until 2 p.m. Royal Commission is now in session. Please be seated.
Yes, Mr Scott.
Thank you, Commissioner. Could the witness please be shown a new document, doc ID CTH.3023.003, sorry, say that again, CTH.3023.0013.3051 _R. And that should be Exhibit 2162. I'm going to ask you some questions about this email, Mr. Withnell.
Sure. I'm not sure if I've seen it, but it doesn't look familiar, but I'm happy to proceed.
Okay, thank you. Do you agree that it purports to be an email from Scott Britton to yourself,
Yes.
and that it purports to be dated the 21st of January 2015?
Yes.
And can you see the header at the top of the page that it says DSS comments on DHS welfare integrity options?
Yes.
See that? And you see the time that it's sent next to the date?
Yes.
It says 1440.
Yes.
And you would understand that to be referenced to 2:40 in the afternoon?
It would appear to be, yeah.
And you recall the email I showed you earlier, and just so you can see, perhaps if we take this document down and put up again the previous document, which is Exhibit 266, CTH.2004.0002.0332 _R. Okay, do you see that's the email we were discussing earlier?
Yes.
That was the email that attached the comments on the proposed attachment B. See, you agree with that?
Yes.
The comments from DSS.
Yep.
I just get you to note, please, the time and date of that email, the 21st of January, 9:37, being 9:37 a.m. in the morning. You agree with me on that?
Yes.
Okay, so we'll go back to the email I just showed you before, which was Exhibit 2162, doc ID CTH.3023.0013.3051 _R. So I showed you this email just a few moments ago. Do you recall that? Okay, so I'm just going to ask you at the outset, the opening words of the email, Mark, in response to the points raised by DSS.
I can't read it, sorry.
I'll ask that to be called out, please.
If it's made bigger, I should be able to, but at the moment it's not made bigger.
Can you see that, Mr. Withnell?
Yep.
Okay. So I'm going to ask you at the outset about those opening words in response to the points raised by DSS.
Okay.
Now, would you agree with me that given the time and date that we've just identified, that this must be a response to the points raised by DSS in that attachment?
I would assume so, yes.
Yes. And it's confirmed, isn't it, by the heading PAYG cleanup?
Yes.
Your assumption is
Again, I
confirmed.
imagine so, yeah.
Yes. I'm going to ask you some questions about the first 3 bullet points.
Okay.
So if you could just read those 3 bullet points to yourself without reading them aloud.
read those.
You have. And what I suggest to you is that in these 3 bullet points, Mr. Britton is purporting to describe the proposal that was the subject of the comments from DSS in that previous document. Do you agree with me on that?
Sorry, he's purporting to do what, sorry?
To describe the proposal that was the subject of the DSS comments in the previous, the attachment to the earlier email that day. Do you agree with me on that?
I'll need to reread them. Certainly, I think the first dot point is clarification of what the proposal was that DSS were commenting on, as far as I can recall. Second, I think amplifies that the opportunity to provide information and that there's initial notice that would be available to them. I'm not sure, I don't recall whether that's explicit in the comment, in the proposal that DSS commented on, or if it's just an amplification of one element of that. The third point is what's stated in the proposal that we spoke about earlier about applying the income smoothing. So Mr. Britton is basically reiterating the process with some amplification at this point in time. I'm not sure, having not seen the context or why he's gone to that. He seems really to be reiterating rather than dealing with the issues specifically raised by DSS. That would be my quick reading of it.
I'm asking, well, we'll come to the point about whether or not he deals with the issues raised by DSS, but my question at present is whether those 3 bullet points accurately describe what you understood the proposal to be at that time.
Certainly the first 2 do. The third one I would need to consider a bit further and reread the proposal as we described it at that time. The reason for that is the proposal changed a number of times, obviously, and my memory of these events and the detail of them isn't good for a number of reasons, which is probably not appropriate to go into at the moment, but I would need to just see whether I can confirm that third point is consistent with the proposal at that time.
You want that earlier document to be brought up?
I think I still have the document.
So just to be clear for the record, we're referring, are we, to the document that you should have, which is cth.2004.002.0333 underscore, sorry, not underscore, exhibit 2067. Is that what you're referring to, Mr. Withnell?
It's the last 4 digits are 0334. That's the right one.
That'll be the second page of the document that I...
Oh, sorry. On page 1, is that? I'm not quite sure where you are.
Just for the record, identifying the document you're referring to, but you're interested, you're checking the document with the page with the last four digits of 0334. Is that right?
That seems to be the page where PAYG cleanup is. Is that the page you're referring to?
Yes.
Yeah. Yes.
So you need to refer to that to check whether the third bullet point in the email from Mr. Britton to yourself on the 21st of January are consistent. Is that what you're saying?
Yes, because the proposal's changed so much and the wording, I just need to see that that's consistent, that's all. Could I have those 3 dot points brought up for me, please?
Not that box. It's a, yes.
No, sorry, I meant I've got the other one.
Yeah, it's just the
first
3
document. Yeah, sorry.
bullet points in the email of the 21st of January.
Yep, that's correct. First dot point adds a little bit of information, but is fundamentally, I think, the same. That PAYG matches will provide the information. It does add additional information, that the matches include the period the individual was employed, which I don't think is referenced in the draft potential priority.
Sorry, what do you say is not identified in the draft?
That the PAYG match includes the period the individual was employed.
Right. Does that change the substance of what's being described?
That DSS have described?
Well, this is a document. This is not DSS's description.
No. So I'm sorry, not sure what your question is.
So do those words you've just highlighted change the substance of the 2 descriptions of the proposal?
Not fundamentally, the first one doesn't. It just adds more information that says that the ATO data has the period of employment for the individual, which isn't referenced in the previous.
So you'd agree with me so far you've identified no differences in substance between the 2 descriptions of the proposal, is that right?
Of dot point 1, yes.
Okay, well then dot point 2.
I think the second dot point is consistent. It's worded slightly differently, but it says that the recipient will have an opportunity to provide the information on a fortnightly of the income so that any debts can be assessed accordingly. So it's consistent with customer having an opportunity to update any information prior to it being applied. So I think it's worded quite differently, but it's consistent, I think.
They're the same in substance, aren't they?
I think so, that one.
Third bullet point?
Third one. The first statement, if the recipient does not respond or chooses not to provide a fortnightly breakdown, I think is different to the draft or potential priority proposal. I'm just trying to confirm that. It's written quite differently, but it's to a degree consistent, I think, with dot point or point C, but worded somewhat differently.
Well, can I just ask you to be clear, Mr. Withnell? Are you saying that this third dot point was, in effect, proposal by Mr. Britton to change what had to that point been proposed, or are you saying, or do you accept that he was just purporting to describe in substance what had been articulated in that document upon which DSS had commented?
I think what he's doing is providing information in response to the points raised by DSS. I'm not sure if he's purporting to change anything. I'm not sure, other than providing some information that may be useful in response to the issues raised by DSS.
If he was purporting to propose a change to anything, you would surely have corrected him on that, wouldn't you?
Look, it's possible. I don't remember the detail of this and the context. My sense is there was, at this time, a range of ideas going backwards and forwards between individuals, between DHS and DSS. I would imagine there were a number of meetings, and we were, as I say, at this stage still dealing with, I think, 12 possible ideas, of which this was one. So he was just providing some information back to me. If on closer reading, that's different. Whether I picked that up at the time, I don't know.
So are you saying that this third bullet point is inconsistent with what you understood the proposal to be at this time?
At this time, all I can go on is what's in the PAYG cleanup potential MPP, and they're kind of written quite differently. I'm just trying to see where the difference is. Having not seen this, I don't think, before for several years. I think what he's saying is that in the non-response, a proposal is that the income will be smoothed, which may be consistent with the view at that time, given that we'd only just got the information from DSS. I don't know at what point I read it in detail, whether I would have picked up any inconsistency. It's certainly slightly at variance, I think. but I'm not sure, because they're a little bit different and I haven't had time to consider it and see the context they're coming in. I can't give you a definitive answer, I don't think.
Should have shown you over the next page that this is actually the tail end of the email chain in relation to the DSS comments on the draft. So if we go to the second page and call out the last email before Mr. Britton's email begins, which is an email from yourself,
Yes.
dated the 21st of January, 9:37 a.m. for your consideration. Do not forward.
Yep.
Okay. That's, of course, you'd agree, your earlier email forwarding to Mr. Britton and Mr. Brown the DSS comments on the proposal.
Sure.
And this is at 9:37 a.m. on the 21st of January 2015. We go back to the email from Mr. Britton. As you agreed, this is only, it was later that afternoon at 20 to 3 that Mr. Britton provides his comments. And are you seriously suggesting that at that stage, a matter of hours after DSS had provided their comments, Mr. Britton was proposing a variation to what was the proposal that DSS had commented on?
All I can say is that he may be describing the process as he understood it at that point. I'm not sure how I can go further than that.
Are you saying that he was describing the process contrary to how you understood it at that point?
I would need to go back to...
We will. We'll go back to the first page of the first 3 bullet points. So, you again read that to yourself, not out loud, and then I'll ask your question.
Okay.
You've read it?
Yes.
Is that a description of the process proposed at that time contrary to how you understood the process to be?
I think the first 2 dot points are consistent with how I understood the process. The third dot point, I can't say for sure whether that's how I understood the process at that point in time or is slight variation. I'm not clear.
So what slight variation are you suggesting might be there?
Well, as I've said previously, the notion of income smoothing was starting to become less possible and less likely and less attractive as a means of going forward. And certainly then the application of that, as opposed to providing an assessment which is referenced in dot point 2, I think was becoming less of a consideration, and certainly the DSS advice would have helped to inform that that was less of a consideration. I mean, you're asking me what was in my mind when I received this and what I thought about these at a point almost 8 years ago. There were multiple emails coming through, different people having different views, often slight variations. All I can say, I think, with any certainty is the first two dot points appear to be consistent with my understanding of the process at that time. The third, I think, is an issue that was in some transition and some doubt at that time. And certainly the information from DSS would cast further doubt on the utility of that particular process at that point in time.
All right. Well, I'll just ask that the last bullet points in that section be called out. And I'll again ask you to read those last set of bullet points to yourself without reading them aloud once they're called out. And then I'll ask you some questions about them.
Okay?
You've read that?
Yep.
Would you agree with me that those bullet points seek to justify the process as described in the previous 3 bullet points?
Yes, I think they do.
Okay. Then if we call out the next 2 paragraphs, again, I'll ask you to read those passages to yourself, not aloud.
Yes.
All right. And you'll see that Mr. Britton purports to provide an excerpt from a debt policy advice a couple of years prior.
Yes.
And the excerpt is what's in the quote. You agree with me on that?
Appears to be, yes.
Would you agree with me that excerpt provides no justification whatsoever for using income smoothing to calculate social security entitlements?
Sorry, what was your question again?
Would you agree with me that that excerpt does not provide a legitimate basis to justify the use of income smoothing to calculate social security entitlements?
It doesn't explicitly, I don't think.
And therefore it doesn't at all.
It doesn't rule it out, but it doesn't explicitly say it can be done.
All right. If we could call out the balance of the email which goes over the page, which is some provisions of legislation under the heading requirement to respond. Again, I'll ask you to read it to yourself without reading it aloud. I'll ask you some questions. Read those passages?
Yes.
And you would agree with me, wouldn't you, that they are provisions of legislation that talk about notices?
Yes, they appear to be.
And they say nothing at all about the use of income smoothing to calculate social security entitlements. You would agree with me?
There doesn't appear to be any reference to that.
All right, thank you. Now, I'm going to ask you some more questions about this email, about what, in effect, Mr. Britton was trying to do in this email, okay?
Okay.
Having seen the full context of the email, what I suggest is that what Mr. Britton was trying to do was to justify the proposed process as described in those first 3 bullet points. Would you agree with me about that?
It appears to be the case, yeah.
Is to be the case? And you would agree with me that what follows after those first 3 bullet points provide no basis whatsoever to conclude that the process described in the first 3 bullet points was lawful.
I'm not trying to dodge the question. I'm quite happy to answer it. Sorry, I just need to compose myself before I say what I need to say. I'd hoped it wouldn't come to this. The period we're talking about in the subsequent 18 months was a time of ever-increasing workloads, intense micromanagement, and relentless kind of pressure. One of the legacies of that is there are times when I have trouble focusing and concentrating for periods of time. And I'm not trying to duck your questions or be difficult here. I'm just having trouble holding all the information in my head at this point in time. I've said to a number of people, at times it's kind of like my brain shuts down as a defence when it's trying to deal with too many things. And it's something that I attribute to this 18 months or so, certainly from then. And why I keep asking you to repeat the question is I'm having trouble holding the question in my head at the moment. So I apologise for that. But it is something I've raised previously. And I'm not sure how we proceed from there on that basis. I'm just struggling to actually both read, comprehend and articulate at this particular moment in time.
Are you able to answer the question, Mr. Withnell?
If I'm honest with you totally, Council, I can't remember what the question is. That's the difficulty. That's why I've asked you to repeat it a few times and had to reread. I get these periods of time where I'm just not able to keep everything in my head. In a few minutes I may be able to. It happened frequently going through some of the preparation for this and the statements previously. I found it in matters unrelated to this, an ability to take information in. And I know my memory from that time is seriously impaired, both for professional matters and personal matters. And I'd hoped not to have to say this. I'd hoped I'd been fine. But at this point, with those things, I'm struggling.
You want a 5-minute break? Would that help?
It may, yeah.
All right, we'll adjourn for 5 minutes.
All rise. The Commission stands adjourned for a 5-minute break. Royal Commission is now in session. Please be seated.
Commissioner, we've had some discussions. I believe there's someone with Mr Withnell. He's just outside with her.
Okay, can we fetch him in? Mr Withnell, in light of what you were saying before, it is possible that we could just adjourn your evidence, but we would still need you to come back. You'd have to understand we do need to ask you these questions, so we would still want you in our January tranche of hearings. Is that any better, or would you rather go on?
No, look, I understand that, Commissioner, and thank you. And I'm certainly not trying to avoid providing the evidence. I just want to be able to provide it as best I can. And so it's not a question of whether I want to. It really is a question of whether I'm actually able to think it through and articulate it. And I'm happy to try again now to see how we go.
All right.
And I'll alert you if I'm struggling as I was before.
Okay, thank you.
If the document we were looking at earlier could please be returned to the screen. Just first page of the email. No passages called out, please.
Sorry, Councillor, I didn't hear that.
I'm sorry, I'm giving instructions to the document manager. Now, I think you agreed with me earlier that what Mr. Britton was purporting to do in this email to you was justify the process that is the proposed process that was being described in the first 3 bullet points in this email.
That appears to be the case. I can't be more specific than that, but I think it's him, having read the DSS comments, giving a point of view about those issues.
Yes.
It would appear to be the case. Yeah.
And as an answer to the DSS comments.
I'm not sure if it's a specific answer. It's his thoughts about some of those issues and some reference to both process and other activities. That's really all I can say, that it's just whether it's his initial response, whether it's a firmly considered response or he had some other motivation in there. I can't speak for him at that point. All I can say is that it would be normal if I asked for comment that people would provide a range of comments back that they felt articulated their view of the issues that were raised.
And it's evident from his response that a particular focus is the DSS comments on the use of income smoothing in the proposal.
I'm not sure. I can't actually see the screen, or can't see. It's not big enough for me to actually be able to read.
Well, if we call out the first three bullet points again.
Is it possible to provide me with a hard copy? We'll just make it easier. If you can't, that's fine, but it's just simpler to have it in front of me and cross-reference the two.
I'll just find out if I can.
Sure, thank you.
Commissioner, unfortunately, we don't have a hard copy. It was in the additional documents notified by council assisting.
We can attempt to, if it's a difficulty. It's just harder to do it, that's all.
Mr. Withnell, I'll assure you I'll do my very best to get you a hard copy as soon as I can.
If you're able to tell me the bundle reference number, the tab number, maybe I can find it in the set I've got, but,
Tab 13 should be, Commissioner.
okay.
Thank you.
So you've got that in front of you there.
I do, thank you.
I'm just asking you not to read out, but just to read to yourself again the first 3 bullet points.
Mhm. Okay.
So do you agree with me that in this email, Mr. Britton was focusing his response on the comments about the use of income smoothing to calculate social security entitlements?
He's outlining the process in dot point 3 that he thinks could be used, it's proposed, as he says in the second half of the sentence, it's proposed that that could be used, so he's reiterating what may have been the proposal at that point, or was the proposal at that point.
And in those 3 dot points, he includes in the description of the process the use of income smoothing to calculate social security entitlements.
Yes, I think so, if I heard your question correctly. My reading of those 3 dot points is that he's adding to information that is in the priority document and providing a bit more detail in some places, but largely reiterating what is proposed as best I can see.
And then I'll take you through them, but the point that I'll make in respect of each is that each subsequent point that he makes is to support the proposition that the proposed process as described was lawful.
This is from dot point 4 you're referring?
Take you through each,
Okay, yep,
sorry,
just
indicating what I'm going to do.
Yep.
So, 4th bullet point, he says this approach is consistent with current debt policy. No legislation existing which states how a debt is to be calculated. So he's clearly using language that's seeking to justify the process outlined in the preceding 3 bullet points, correct?
That would appear to be the case.
The next bullet point commences with the words, DHS currently applies a similar process or a data matching program and PAYG compliance interventions where it is unable to obtain the required information from the employer. And again, would you agree with me that is language directed to justifying the process as described in the first 3 bullet points?
Yes, he's describing the process I mentioned earlier where income smoothing is used as an exception, and in fact that's the example I think I gave to the Commissioner's question in relation to when that might occur. So he's using that, I think, to justify the proposal as it was at that time.
And then the next bullet point, the words are, the proposed process does not change a recipient's right of review. Again, would you agree with me, language directed to justifying the process described in the first bullet points?
It would appear to be. Although he's, I think, responding to a very specific point that is made by DSS. I'm just trying to find it. In relation to constraining review rights.
Yes. The next bullet point, the proposal provides for an automated assessment of debt. This will reduce administrative error. Do you see that?
Yes. Yep.
And would you agree with me that the words "this will reduce administrative error" are directed to an assertion that the proposed process as outlined in the 3 first bullet points would be a good thing?
That appears to be what he's suggesting.
And the reference to automated assessment of debt would be consistent with the reference to the digital process in the 2nd bullet point as part of his description of the process.
I'm struggling a little bit with this one, Council. I'm trying to get a sense in my head of what he's meaning by an automated assessment of debt. So the automated assessment would be, at best, indicative. I'm not sure how that reduces administrative error unless it's applied, and he doesn't reference that it would be applied.
That's implicitly what he's saying, isn't it? That it would be applied, I should say.
I'm not sure, I can't say definitively that it is implied. It goes back to the point I raised before lunch, that there's a difference between an assessment and the application of that assessment. And in this, because he's used the words, and I can only take them at face value because I don't have any recollection of this, that he's saying an automated assessment implies indicative assessment, which would need to be confirmed. When he then says this will reduce administrative error, that would only be relevant if the debt assessment was then applied to the recipient record. Because it couldn't be an administrative error if it's an assessment, because it's indicative, it's not a determination. The administrative error would come when there's a determination. So if the automated assessment that he refers to there is then applied, if the debt's correct, it may reduce administrative error in terms of the calculation of debt, which may be the point he's making. I'm just surmising and trying to read between the lines what he's actually saying. Because the two, in my reading it on face value, the two proposals or two propositions in that dot point aren't consistent. So that's why I'm struggling with that.
All right, well then, next bullet point, the reference to the introduction of single touch payroll.
Yes? Mm-hmm.
If you've got the document with the DSS comments in front of you, you'll see from the last bullet point in the box what that's a reference to.
Yes. Mm-hmm.
And the point that was being made in the comment in that bullet point by DSS was that single touch payroll would provide DHS with access to accurate real-time employment details to provide a ready basis to calculate debts and assist in more accurately assessing entitlements. You see that?
Yes. Yep.
So that's what that's clearly responding to.
What I understand from what he's saying there is that yes, single touch payroll will provide DHS with more timely employment income details. That was a matter we talked about earlier today in relation to the exploratory work we did in 2014. As I indicated at the time, earlier this morning, it wasn't likely to be in place until I think I said 2018 or 19. The point I think Mr. Britton is making there, and it's consistent with the point I made this morning about date of effect, it won't address historical non-compliance. It would only address prospective non-compliance because the date of effect, or because there will be no change to the date of effect, because there will be no change to the way in which income was treated and rates determined. I'm not sure if I've explained that clearly, what I'm trying to say there. What I'm trying to articulate is what I articulated this morning, that any legislative change would only really make sense on a prospective basis. And one of the issues we were looking at is whether there was any value in looking at a change to legislation to enable an integration with single touch payroll at a point in the future, but potentially to bring that forward and start a process that may well be annual, but then gradually getting closer, as DHS say, to more real-time employment income. What he's saying is it won't address historical non-compliance, and as I indicated earlier, the shift at the beginning of January was to look at whether what we've been looking at in relation to PAYG data prospectively may be applicable retrospectively. I think what DSS are saying in their advice, which, you know, in large part, if not all, I agree with, that no, that wouldn't be appropriate for a range of reasons, which they go into about the Keating High Court decision about retrospective changes and so on. What Mr. Britton appears to be saying is that single touch payroll will not address historical non-compliance, which is true, as far as I could see, although it may not be entirely true because if it triggers a reassessment in some form, it may highlight an issue, but at that point there was no real understanding of how those two processes would merge, so that would be speculative at best. What he's then saying is the estimated savings from this proposal are largely debt. I'm assuming you're familiar with the savings methodology and how that's calculated, but it's predicated fundamentally on the debt that's been incurred and extrapolated from there. So single touch payroll, because it doesn't address historical non-compliance, wouldn't address any debts and therefore savings raised by this proposal. So DHS's point, where are we? Just trying to find the point, sorry. I may have been reading into something they said where they talk about, where are we? Their second to last dot point, annual data matching will by its nature lead to the raising of larger debts rather than identifying non-compliance earlier. I'm not sure that I agree with that necessarily. And larger debts are more difficult to recover, which is true, and would result in a significant increase in the debt base. I agree, larger debts are more difficult to recover. Whether it would result in a significant increase in the debt base, I'm not sure, given that, you know, something in the order of 80% of debts raised in any given year were not as a result of compliance action. So it may have an impact on the overall debt base, but I'm not sure to what extent that would play out.
Before you go on, Mr. Scott, Ms Hogan-Doran, I don't think we'll be starting Ms Campbell this afternoon. You might convey, well, I'm not sure if it's my apologies exactly, but I am sorry that she's had to wait the extra day in the expectation of giving evidence.
Yes.
To no avail, but I think if she can get a plane now, she's welcome to, and I think we might just have to get her back in January.
Thank you, Commissioner. I think I've had some discussions with Senior Counsel Assisting as to when Ms Campbell might return. She does have commitments that mean January will be difficult.
All right, I'll leave
but
that.
we will make arrangements to ensure that she does return so that those additional matters can be taken up with her.
Thanks very much. Yes, Mr. Scott.
Thank you, Commissioner.
Sorry, I'm not sure if I've addressed your question there. I've just been trying to think my way through what he's trying to say relative to what DSS have said. So
I'm just asking you whether that's, it appears to you that is a purported response to the DSS comments on the proposal. And in particular, the comment in the last bullet point in that box in the other document.
in relation to the last point,
I'm not asking you to indicate whether you agree with the DSS comments. I'm just asking you to whether you agree that it's evident that that is responding to the DSS comment in that bullet point.
in part, yes. Yep. Certainly the first sentence, first sentence certainly is doing that. What he's suggesting is that the ATO single touch payroll won't address historical non-compliance, which I don't think is an issue raised by DSS.
When you say don't think is raised by DSS, are you saying that?
Not as explicitly, although it is embedded in their point in relation to the Keating High Court decision. But it's not a direct link.
Can I just ask you about that point in the Keating High Court decision? So that's the
Sure.
first bullet point at the top of the document with the last four digits, 0335, and then compare that with the last bullet point in the email that you're looking at with the last four digits of 3051. You agree that he's purporting in that bullet point in that email to respond to that comment about the Keating decision?
What he appears to be arguing is that and again, I'm trying to interpret rather than it being definitive.
I don't need you to tell me what he's appearing to argue. I'm just asking you to tell me whether you agree that he's purporting to make an argument about what DSS have said about the Keating High Court decision.
He's suggesting that there's no retrospective legislative change required, is my reading of his dot point. The Keating High Court decision, my reading of it is that application of legislative change retrospectively is limited. So I'm not quite clear what the point is here.
Mr. Scott, perhaps we can look at the documents for ourselves and see.
Yes. Perhaps if I can try and just come back to the question I asked you before the break. Do you agree with me that what Mr. Britton sorry, I'll withdraw that. Do you agree with me that Mr. Britton's email does not provide a legitimate response to the criticisms made by DSS about the proposal in respect of income smoothing?
I don't think it provides a robust response to the issue of income smoothing. I think he's provided a view, but I'm not clear, it's not clear to me that it makes a robust case based on my reading of it there.
Not even a plausible response, is it?
Sorry?
It's not even a plausible response, is it?
Look, I think it's limited, and it doesn't address all of the issues that the DSS have raised. In large part, it's just explaining the process again with some commentary.
Do you agree with me? It's not a plausible response.
I think on the whole, I would have to say that it's limited.
Not plausible.
Look, there are a certain number of elements in there that that obviously would need to be explored further, but in and of itself, I don't think it makes a case necessarily for income smoothing, if that's what you're seeking, what you're asking.
All right. A document can be taken down. The next document could please be shown CTH.2004.0002.0345 _ the exhibit is 2163. I'm just going to ask you a couple of questions so I can confirm that you acknowledge what this document is, Mr. Withnell. You see that purports to be an email from yourself to Ms. Golightly, dated the 21st of January 2015.
Yep.
And you see the attachments referred to, revised new draft brief to Minister Morrison.
Yes.
And you see it's from you, says, Melissa, I have attached the new draft brief.
Yes.
Okay, do you, and if the next document could please be shown, document which is Exhibit 2164, Doc ID CTH.2004.0002.0346. Sorry, could we go back to the previous email, please? Just ask you to note the time on this email, Mr. Withnell. To see that's the time of that email is 16:45, that is 4:45 p.m.
Yes.
Okay, and to recall, perhaps I think you've got the previous email in front of you, that was the same date, but at 2:40 p.m. Okay. All right. Now we go to the attachment, which is CTH.2004.0002.0346 _ Exhibit 2164. See, that's another draft of the executive minute to the minister
Yes.
that we've been discussing. Okay. You can go to page 14, which is the last 4 digits of the doc ID is 0359. You see at the bottom of that page, the heading, and we'll call it out, the section headed PAYG cleanup.
Yes. Yeah.
Just ask you to read that to yourself without reading it aloud.
Yes.
And if we call out the passages D through to H on the next page, and I'll ask you to read that out again, and I'm going to ask you some questions, okay?
Yes.
All right, so we'll just go back to those previous 3 paragraphs on the previous page. Call them out again. You can see, can you see in paragraph C the words starting on about the 4th line, the assessment will use an income smoothing methodology to apportion the customer's income over the time of employment rather than the current cumbersome process whereby the department has to determine and apply income on a fortnightly basis.
Yes.
Okay, I'm going to ask you a question about that. Now, would you agree with me that notwithstanding the advice from DSS, the legal advice from DSS, that income smoothing would be unlawful? In this draft, which you have provided to Ms. Golightly, you have retained the proposal for income smoothing.
Can I refer you back to the covering email, please? Could you call that?
Exhibit 2163, doc ID CTH.2004.0002.0345_R. There's something important in this document.
Yes, so I refer you to the last sentence, and particularly the last 3 words.
Okay, and what's the significance of that?
Well, what I'm saying there is that I've started or tried to address some of the issues raised by DSS, but not all of them. What I'm not aware of is which I have addressed and whether I'd started to look at the PAYG issues.
Okay. Well, you didn't address the income smoothing issue at all in the draft, did you?
Well, as I say there, I've started to address them, but not exhaustively. I'm going to do some more tomorrow, and if she's got any comments at this point, that would be helpful. Often the brief writing with Ms. Golightly was quite iterative in this regard. There would be discussions and things changed, and it would be over a period of time, not here's a view, she makes comments, comes back. It would be much more interactive. What I'm saying there is whether she was wanting, at that point, as I've said, don't worry too much about the proofreading or finessing. It's really, I've done some changes, but I haven't done all of the changes or addressed all of the issues raised by DSS. What I'm not clear about, having not done a comparison of that document to previous ones where I've made changes, or whether I've started to address, started to address issues in relation to PAYG, but essentially what it looks like from above, I've looked at the task force and the issue in relation to prosecutions, but still have others to go.
This is an exhibit, Commissioner, but I don't have the exhibit number. I just want to bring up something from document exhibit AWI.9999.0001.0005. Exhibit 2031. Go to page 9 and call out paragraph 57 and pages 9 and 10 of that statement. Sorry. You just start with the part of the document that commences 00, the last 4 digits, 0005. The doc ID should be AWI.9999.0001.0005. 0005. Underscore R.
If you need to show this to the witness, I can provide a copy of Mr Whitecross's statement.
Thank you.
I'm causing this to be provided to you, Mr Withnell, to ease your understanding. Sure. So this is a statement of someone called Andrew Whitecross, provided to the Commission.
Okay.
Do you remember someone called Andrew Whitecross?
The name doesn't ring a bell. That's not, I can't, obviously can't rule out whether I know him or not, but the name doesn't ring a bell for me. Can you give me context of where he's from or?
Would it assist you if I told you that he was, in this period that we're discussing, in early 2015, an employee of the Department of Social Services?
Okay.
And if we go to page 9 of that statement and call out the passage in paragraph 57 that goes over to the following page, could I ask you to read that passage to yourself without reading it aloud?
So just paragraph 57?
Yes.
Yep. Okay.
You've read that?
Yes.
Do you have any recollection at all of that meeting with Mr Whitecross and the other person referred to? Other persons referred to, Miss Halbert and Miss Rule?
No. As I say, there were many meetings on different elements of the proposals at that time. I don't recall this one specifically.
All right. Do you have any recollection at all of meeting?
Teleconference?
Yes, sorry. Via of that nature, via teleconference?
No, I don't have any recollection of any meetings at all in that period, to be fair.
And do you have any recollection at all of any meetings by teleconference or otherwise with representatives of DSS in that period in which you were advised to the effect that income averaging could not be applied to determine that an overpayment had occurred in a given fortnight and that additional information would still need to be collected in order to be satisfied that the apportioned income had actually been received in the relevant fortnight?
As I say, I don't recall the meeting. Just rereading the advice that he recalls giving. Sorry, what's your question now in relation to those?
you recall any meeting at about this time with representatives of DSS, whether by teleconference or otherwise, in which representatives of DSS.
No, I don't recall any specific meetings, no.
I'm not asking about specific meetings, I'm asking whether you recall any meeting with any representative of DSS at about this time in which those representatives use words to the effect of what's in paragraph B under paragraph 57.
As I say, I don't recall the meeting specifically or any particular meeting specifically. The advice he's giving in paragraph B, I think is correct in relation to, or is consistent, sorry, with some of the points I made earlier today about, in some instances, that it would be unlikely to be accurate. He goes on in point C to identify that the circumstance I indicated as less likely to create an inaccuracy where the person had received social security payments for the entire period. Whether that view is informed by this and discussions that were had or was arrived at separately, I'm not able to say. I simply don't recall.
Okay. Well, I suggest to you that a teleconference did occur involving the persons mentioned in this paragraph on this date, the 22nd of January 2015.
Yep.
You can agree with me or not?
Well, I've no reason to doubt that. If he has suggested it occurred, it may well have.
And that his description of what occurred at that meeting is accurate.
As I say, I don't have recollection of the meeting, so I don't know if his description is accurate or not.
Were you prepared to accept?
I think the points that he makes would accord with my view, or the view that I was starting to form at this time.
So the points being points in paragraphs A through to D?
Certainly point one, I'm not sure, because I don't recall the meeting. B, I think is consistent with the view that I was had either formed or was forming. C is consistent with what I said this morning about those circumstances where it's less likely to be inaccurate. D, D, I think he's right that small discrepancies would be unlikely to reflect misreporting of income, and that's why there was a threshold in relation to the variation to try and avoid those issues. Whether I found the feedback frustrating, I don't know. And certainly the second half of point E is inconsistent with my recollection of my view and the fact that we had, I think from the data match, eliminated those with smaller discrepancies. That's my understanding at this point.
So I'm just going to specifically put it to you that at this meeting, you expressed frustration in response to the advice provided by Mr. Whitecross.
Well, Councillor, I don't know if I expressed frustration or not. because I don't recall the meeting, it would be unusual for me, to be honest, but at that point in time, I was going from meeting to meeting, from proposal to proposal, trying to resolve issues, while under considerable pressure from the Deputy Secretary. And so whether the frustration, if I showed it, was related to his advice or just general frustration about how all of the processes were going or the amount of work that had been involved and the amount of trying to reconcile different views, I don't know. As I say, I don't recall the meeting, so I don't know whether I was frustrated, what I was frustrated about if I was. I'm not sure how I can answer that.
Well, what I suggest is that you were frustrated that DSS was maintaining the position that it would not support a proposal using income smoothing.
As I say, I don't think I can change my answer. I just don't recall the meeting. So if Mr. Whitecross had formed a view that I was frustrated or appeared to find it frustrating, I don't know whether I was, if it was in relation to that, or whether it was just a general level of frustration at that point in time with the whole broad process, not just this particular one. I simply don't know.
I suggest to you you were frustrated with the advice that Mr. Whitecross provided, because without the use of income smoothing, it was not possible for the proposal to achieve the savings that were proposed.
Without income smoothing, it would have been more difficult to achieve the savings, but I don't think I could say that the savings wouldn't be achieved.
It just wouldn't have been possible, I suggest, Mr. Withnell.
I'm not sure what the basis is for making that assertion.
Well, without income smoothing, it would be necessary for the previously ordinary approach to be applied, that is for a compliance officer to actually investigate the discrepancy. And that's a time-consuming and, as the proposal had described, cumbersome exercise.
Not necessarily, because the other part of the proposal was to provide information to the recipient and ask them in an online environment to reconcile that information, either to confirm the information was correct or to correct it. That would lead you to a point where income smoothing, if they corrected the information, income smoothing wouldn't apply because the customer had provided the information to reconcile the discrepancy.
But as I think you will have seen from the last version, the description of the process in Mr. Britton's email, it was proposed that if the recipient didn't respond, their entitlement would be assessed using income smoothing. And that was an essential part of the proposal, wasn't it, at that time?
Not sure if it's an essential part of the proposal, but it was part of the proposal at that point, as far as I recall. But things were moving fairly fast in some of this, and so things could change quite quickly. As I say, I'm speculating a bit here and trying to reconstruct what my view was from this period, but I have a general view at what point specifically things changed, I'm not able to determine. So I'm struggling a bit to find an answer that's useful to you.
Well, if the witness could please be shown Exhibit 1964, Doc ID CTH.2007.0002.6780_R. Now, just going to ask you to read this to yourself, and then I'm going to ask you to confirm whether it is what it purports to be.
Yes.
Do you agree that's an email from Miss Golightly to Miss Campbell, the Secretary of the Department of the time,
Yes. Yep.
dated the 22nd of January 2015?
Yes.
Your copy to the email?
Yep.
And the attachments are revised new draft to Minister Morrison. You agree with me?
Yes. Yep.
And it purports to provide a revised draft brief attached. And if we go then to exhibit number 1965, Doc ID CTH.2007.0002.6781.
At Exhibit 1965, I can provide a copy to the witness.
Yes, Ms Hagendorf.
Now, just ask you to confirm, Mr Withnell, that you would agree that this is a revised version of the brief to Mr Morrison?
It would appear to be.
Okay. And if we go then, please, to page 9, which has the last 4 digits, 6789. And I'm going to ask you to read to yourself, not aloud, the passage headed PAYG cleanup that goes over the next page.
Okay.
All right. Now, would you agree with me that this version of the document does not have the reference to income smoothing in it?
Correct.
You would agree with me, would you, that it retained the proposal that the customer will be presented via their online account with the information obtained from the ATO? That's the third bullet point.
Yes.
And an assessment of their correct welfare entitlement based on that information.
Yes.
And that would mean, of course, an assessment using income smoothing, wouldn't it?
Yes. Yep.
And then it says the customer will have an opportunity to update the information prior to it being applied to their Centrelink record.
Correct.
Right. And if it's implicit in that, isn't it, that if the customer doesn't take that opportunity up, it will be applied to their Centrelink record. That is the assessment using income smoothing.
I think it's silent on that point, I think, isn't it? The,
I accept it doesn't say it expressly, but I'm saying it's implicit. Because to apply the ATO data necessarily requires income smoothing, doesn't it?
to apply the ATO data would require income smoothing, but that's not what this says. It says they'll be provided with the information obtained from the ATO and an assessment of an entitlement based on that information, and the customer will have an opportunity to update the information prior to it being applied to their Centrelink record. So it says, here's what we'll provide to the customer. This is my reading of it. Here's what we're providing to the customer, the amount they declared to us, an assessment of what impact that may have. They then have the opportunity to update that, and I would read it as saying, update the information, as it says in the second sentence, part of that sentence, prior to it being applied. I'll acknowledge that there's a degree of ambiguity there, but my reading of it would be, that it wouldn't be applied until the customer had taken the opportunity to update it. It's the opportunity to update. I think what's missing is the update and confirm the information. So I think there's ambiguity. I understand the point you're making. But I think it's really making that key point, the three key points there. We would provide the amount declared to us and the amount declared from the ATO. That's the first point. Secondly, using the ATO data and that information, we have some indicative assessment of their correct welfare entitlement based on that information, and providing them the opportunity to update or confirm, although confirm's not in there, but, you know.
And then if they don't?
Well, it's silent on that point, I think.
Right, and so it's not much good talking about 866,857 interventions resulting in 1.2 billion gross savings if you have to carve out of that everybody who doesn't bother responding, is it?
I think there would certainly be some reduction, I agree with you. What level that reduction would be, I wouldn't be able to say at this point. And a lot would hinge on the communication with recipients, encouraging them to go online and confirm or correct the information.
But perhaps more to the point, it also says that the ATO data is a trusted source and it removes the need for the department to be dependent on customer and business information. The reliance is on the ATO data as the primary evidence. So if you can rely on the ATO data as primary evidence without the need for customer information, what's that a reference to, if not using the ATO data in the way we've discussed, applied to the record if no other information is provided?
The only, I'm just trying to think what why it's phrased in that way. The only thing I can think, and I can't be definitive, would be that the ATO data, if was accepted by the customer, wouldn't require the customer to provide additional information or for business to provide additional information. we would accept that the customer had agreed that the ATO was a reasonable source and it reflected what they understood. But I'd have to say, on rereading that now, I think it's a bit unclear.
When you say that we would accept that the customer had agreed that the ATO was a reasonable source, are you talking about if the customer doesn't respond to the initial contact?
Can you just repeat the question for me, please?
So you just used the words that we would accept that the customer had agreed that the ATO was a reasonable source and it reflected what they understood. Okay, and that's in reference to the passage that you were just asked questions about by the Commissioner.
Okay.
Are you purporting to say that a non-response by the customer to an initial contact by the department indicating that ATO data was going to be used, you understood that to be an acceptance?
No,
By the customer.
that's not what I'm saying.
Okay, what are you saying then, please?
What I'm saying is that in some compliance review activity, or a large part of compliance review activity, additional information had to be provided even though we already had the ATO data. So we've always had the ATO data for many years, so it was there. What was then you asked for is either additional information from the recipient or additional information from other third parties, for example, an employer or business, as appropriate. What we're saying there, I think, my reading of it, is that rather than have to get the customer to find the documentary evidence or approach third parties to get additional evidence and information, we could use the ATO data as that trusted source of information when accepted by the recipient.
All right.
That's how I'm reading that now. I'm not sure what I can add to that.
The witness please be shown Exhibit 2169, which is DSS.5060.0001.0490. Sorry, wrong one. Should be Exhibit 841 capital A, which is CTH.3008.0007.8877_R. Again, this is going to be an email, Mr. Withnell, which has an attachment. I'm just going to ask you to confirm you see what the email is.
I'm still waiting for it to come up.
Yes.
Commissioner, I can provide a copy of the email and the attachment,
I might just give the doc ID again.
assuming that's the right one.
It's exhibit, oh, there it is.
Oh, I'm sorry. Thank you.
So the email you can see is from Miss Halbert. Recall Miss Halbert was an employee of the DSS.
Yes.
To Melissa Golightly. and CC to yourself. Do you accept that?
Yes.
Date of the 23rd of January 2015. Refers to attachments, including revised new draft brief. See that?
Yes.
All right. I'm going to ask you about the attachment, which is Exhibit 841, capital B, CTH.3008.0007.8879.
Yes.
Now, you've got that? Should be coming up on the screen. You agree it's another version of this draft brief to Mr. Morrison?
It appears to be, yes.
Okay, and I'm just going to call out the passage under the heading PAYG cleanup on pages 9 and 10, and you should have that there in front of you, and I'll just ask you to read it to yourself again.
Yes. Yep. Sorry. Yes. Okay.
Now, you see the yellow highlighting on the last bullet point in that passage?
Yes.
I'm putting to you that words in that yellow highlighting have been added by Miss Halbert.
I can't answer that question. I don't know whether she added it or it was already in the brief and she's highlighted. I don't know how I can assist you with that.
And I'm putting to you that those words are a reflection of the fact that in order to implement the proposal that's described there, there would need to be legislative change to make the income averaging that was an essential part of the proposal lawful.
Sorry, your question, Council, was...
Words in the yellow highlighting in the last bullet point are a reflection of the fact, or a reflection of the DSS advice, that legislative change would be necessary in order for the proposal to be lawful, because the proposal involved the use of income smoothing.
Well, it says that, obviously says, as it says, the approach would involve legislative change. It doesn't say which particular elements require legislative change. And as I say, it's not clear to me whether we had already put that in or it was added in by Ms Halbert. I don't know. either way, she's provided that as advice, or it's been added in previously based on previous advice. I don't know which. I can't say that definitively. So,
I'll show you another document. Document is Exhibit 2171, CTH.4700.0001.2356_R. Actually, instead, I might show you instead Exhibit 2068, CTH.4700.0001.2404_R. Now, do you see that's the final brief to the then Minister for Social Services?
yes, yep.
And it's been dated, and the signature block where the Minister's signature would appear has been redacted.
Yes.
And then if we go to the 10th page of the document, which has the last four digits 2413, when that's brought up, I'll ask you to read what appears on that 10th page. Just to yourself, not aloud.
Could I have it larger, please?
Yes, if we could enlarge that page.
Thank you.
I'd provide a copy.
Thanks, Ms. Oakendorf.
I'm just going to open it at the page.
Thanks.
Now you'll see that in the third bullet point, it also continues, also had the words about presenting the information obtained from the ATO. See that? Yep. Which we know, and an assessment of their correct welfare entitlement based on this information. You see that?
Yes.
Which we know would be an assessment using income smoothing.
Yes.
And the customer will have an opportunity to update the information prior to it being applied to their Centrelink record.
Correct.
I suggest that even at this stage of the briefing to Minister Morrison, it's proposed that if the customer does not take up that opportunity, the assessment using income smoothing will be applied to the customer's record.
Sorry to ask, what was your question again? Sorry, I apologise for...
Question is, do you agree with me that even at this stage, when the proposal is put to Minister Morrison, it involves an assessment of entitlement based on income smoothing being applied to the customer's record if they don't take up the opportunity to update their information?
I think the best I could say is that it could be inferred, but it's not explicit. There's ambiguity in the sentence, the customer will have an opportunity to update the information prior to it being applied to their Centrelink record. I accept that there's some ambiguity in that. But there's nothing specific that then says, if they choose not to, here's what will happen. So whether that can be inferred, obviously it's one interpretation, yes.
There's a reference to the ATO data as being the primary evidence rather than just a trigger. What can it be evidence of other than overpayment? And evidence implies that it's being used as evidence.
It's in the next bullet point, Mr. Withnell.
Sorry, I missed that.
The last sentence in the next bullet point is what the Commissioner is referring to.
Well, as I indicated before, if the recipient accepts the information from the ATO as being a reasonable reflection of their circumstances, no further evidence is required. Whereas in the current, or in the process preceding this, the information from the ATO was not provided necessarily to the recipient and certainly wasn't provided up front. Often requests were made of other parties prior to a whole picture being presented. So there's a shift there. I think what I would say, I think at this point, is that there's still a way to go in firming up exactly what the process might be. Whether the inference you're suggesting that the ATO data could be used irrespective of the customer's acceptance of it, I think is not clear.
And can you see anything on that page which would require legislative change if in fact there's not a different approach to assessment of entitlement?
If it was a change to the assessment of entitlement or the application of that assessment based on the ATO data and an income smoothing approach, my understanding is at the very least it would require policy change, but I'm not familiar enough with the legislation, certainly at this level of time removed, to understand whether the legislation itself would need it to be changed. If DSS have advised that that would be the case, and that could be inferred from their dot point, whether it relates to income smoothing or something else, I'm not sure. It's not explicit.
But what else could there be there that it would relate to?
It could be the provision of information. I simply don't know. I would assume most reasonably it applies to utilising the income smoothing approach, but I can't be definitive. I don't know the legislation carefully enough, I'm sorry.
You can see the last bullet point there may be a need to be a change of policy to enable the use of the ATO data in this way.
Yes.
DSS has also advised that legislative change would also be needed to implement this initiative.
Yes.
Now, the use of the ATO data in this way must be a reference to the use of ATO data to calculate entitlement, I suggest.
Look, it may be. It's not definitive.
Can you think of any other interpretation of those words?
It may relate to the provision of the data to the individual. I'm not sure. That's the only other. The data would only be used, it would be provided to the individual, which was a new thing up front. Using that data to give an indicative assessment would be a new arrangement. Either of those may require policy change, I don't know. At the time I may have known, but now I don't. The legislative change, I presume, would be related to the application of the assessment to the customer record in some form. That's my assumption, but again, it's not definitive. I'm unclear if there's anything else that may require legislative change.
You would be aware of the difficulties that the government was having with passing legislation in the Senate in the year this relates to, wouldn't you?
I probably would have been at the time, but I don't recall it now.
And in any event, the chances of getting legislative change passed in time for the 2015-16 budget measure was slim to none, wasn't it?
I think getting any legislative change is problematic at different times. And that's why I think it says we're still working with DSS on developing this proposal. So it's a work in progress, I would suggest at this point. And we're flagging there's still some work to be done.
But I would suggest that you and your colleagues in DHS had no intention whatsoever of changing the proposal so that it would not use income smoothing.
No, I don't accept that. Whether there were others in DHS who had that view, I can't speak for them. In my view, and certainly whether at this point or later, in the next week or two after this, the view that it couldn't be used was the view that I had and that I iterated on a number of occasions. Whether that's as a result of discussions with DSS, a result of discussions internally, a result of my own thinking, I don't know, maybe a combination of all three. But I recall quite clearly at times making that point in a number of meetings, discussions, forums, that using the ATO data to generate an actual debt shouldn't be done.
Shouldn't be done.
I think they're the words. I'm not sure what words I used previously or what exactly my words would have been at the time, but basically that it would likely create incorrect calculations.
I suggest to you the words in this last bullet point that are called out, that we have been working with DSS on developing this proposal and will continue to do so, can only mean there was an intention to attempt to persuade DSS to withdraw its opposition to the proposal in disregard of its legal advice.
No, I don't think that's the case. I think with all of these proposals, there were discussions with a range of agencies to work through them. Normally, these sorts of discussions would have been done prior to them going to ministers and would have been settled. In this instance, because of the speed with which this was required. Some of those discussions were happening concurrently with advice being provided. In regard to that, I think the settled position is much more reflected in the MPP, but not necessarily at this point, which I think that last dot point suggests is still a work in progress. I think the assertion that the last statement, I've been working with DSS on developing this proposal, is somehow a suggestion that it was us to convince them. I think is, certainly from my perspective, incorrect. Others may have had that view. I can't speak for Go Lightly, obviously, and I can't speak for others, but my reading of that is that there's work still to be done, and we'll keep working on this to see if we can reach a point of agreement.
Commissioner, I might take a few more hours with this witness. Are you content to proceed?
All right then. Well, that being the case then, look, I'm sorry, Mr. Withnell, I'm afraid you are going to have to come back in January because we just can't finish this today. We will adjourn for the afternoon then, 10 a.m. Monday.
All rise. The Commission stands adjourned until 10 a.m. on Monday.